it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas kneeling strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial. Yeah, 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 yeah. Yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in check. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the free. We the California's rolling deep on 9. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you lost downstream, we gon' guide you like Californians. Yeah, yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big, you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing, got a Shamrock spark.
Yeah, yeah. Junkie, 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 junkie.
Susie, Shamrock, Shamrock.
Junkie, 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 junkie.
Juicy, Shamrock, Shamrock.
Girl, we the California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, 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 we stay in the mix. 4 names, 1 flame, can't remix this. Oh, oh, yeah, yeah. Oh. Californians, Californians, yes. Ah. Let's go. Oh, let's go. Oh, let's go.
Good morning, good morning, good morning, good morning, everybody. What's up? What's up? What's up? Oh, are y'all ready for this? Oh man, put a 1 in the chat if you're ready for to see how the defense is gonna put on defense that is not a defense, but it's gonna be the defense that they present. Y'all put a 1 in the chat if y'all ready to see this defense. You know, I was thinking to myself, and y'all can correct me if I'm wrong. What the hell was their defense? Why did they come to trial? Did anybody put on the defense at all? Or were they using the Shaggy? It wasn't me. What are we doing here? Welcome to all our new chatters, all our new subs. I'm your girl, Sweet P. Oh my gosh, welcome over here to take it to trial. This case is, you know, a lot of y'all may be coming from the premiere, which is awesome. It's a purpose, the reason why I did that premiere like that. It's so you can kind of like flow into things. So now we're going to defense statement this morning. But I just don't even understand. Nobody said why 5 people drove from Jacksonville to Tampa. The only person that had an excuse was Alicia, because she said she was not with her boo. I mean, she wasn't with the crew. She was with her boo. So she's the only person that really gave an excuse. All the other ones, why were they up there? I need to know, why were they up there? Nobody has said anything. And do you know, as we watched the trial that they all got convicted in, the defense attorneys were basically saying, look, you don't know who was in the Impala. Okay, well, the state is saying it doesn't matter who was in the Impala, who was in the Chevy Cruze, they were all guilty. That's all they were saying. Well, I don't know how they up there. And yeah, that's all they were saying. Are you serious? That's not going to be a good defense. That's not going to be a good defense at all. Yeah, they got to try to, and that's the problem. They had nothing else. They had nothing else to say. Nobody had an alibi. They didn't go to not one club. All the clubs they went to was to go look for Foolio. Nothing else. Like, if that's not, they need to go down just for all the premeditation. It was so premeditated. It was premeditated. I'm saying premeditation. I don't know. What a mess. So yeah, I don't think it's nothing that they're gonna be able to do. I'll get some polls and surveys to go out as we're going through this. See, y'all can kind of see. Yeah, Sean basically admitted it on the CM when he got up there and he said, "I'm so remorseful." Yeah, you know, the prosecutor was like, "You drove up there." Sean is the problem. Sean supplied the weapons. He supplied the gas. He got the car. I mean, he even probably gave him $5 on that McDonald's meal. Like Sean, if no Sean, I don't know if this ever goes down because I don't think that Isaiah wanted to put miles on his BMW. So there you go. And the Chevy Cruise, they down for the cause. They like tag team. They trying to get over there with their uncle and their brother and they girlfriend and they daddy that's all in jail. So they was just trying to go join the family. So them two, they was just trying to go join. That's what they were trying to do. They were just trying to go join the gang. And they were just trying to figure out an easy way in because they couldn't never get on the visitation list because they had all types of issues in the background. So them two was just down for the cause. I bet you. I'm trying to tell you because Isaiah Chance ain't paid for nothing because J. Rock, J. whoever his name is, he the one paid for the actual the hotel, the Airbnb. You know, the more and more I look at this, like, gosh, y'all know Alicia, she fighting for a new trial. Her next hearing is gonna be May 22nd, so make sure we will be covering it. I don't know. Like the more and more I think about it, she got to be really, 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 really stupid. And I don't believe she really, really stupid, or she really know everything, or she know a lot more than what she's saying. She may not knew when they drove down there. I'll give her that. But there's no way we going down there in Impala and the same guy that I rode down here with, bae, he ain't in the car. He done took his car and went somewhere else, and now we got to pay $200 for an Uber. Babe, I got questions. I need to understand this. Now, it could be that, and then she just don't want to flip on her boo. But once my life became on the line, I'm impregnated with your child. I think there should be a mutual understanding, Isaiah, that I need to flip on you, babe. You take this L so I can go out here and raise our child. But they sitting on the phone in jail, sexting, and him telling her how to run the case. So there you go. But I ain't gonna even hold you. Those are just my thoughts and my thing in regards to this. Miss Felony said, "Look, I'm here for this blasphemy today." I know that's right. Welcome in, welcome in. I'm so glad to have you over here. Good morning, good afternoon, good evening, depending on what time zone you in and where you at in this world. Hey, Jason. Good morning. Hey, real happy. Good morning. Hey, lovely Lynn. What's up, Martina? Holding it down. I got the M&M crew. Where's the other M? Hey, Barbie. Oh, that's so cute. I like that. That's a cute handle. How pretty. Welcome over here. Hey, Sweat. Did you see? Hey, did y'all see that clip that I made about they say they want shop for that old Sweat equity? Somebody better tell me what the heck Sweat equity is about. I was like, oh my goodness. Sean should have been shaking in his boot. He should have peed on himself right there when he heard that. Oh, they want him in there to abuse him. Hey, Jason, thank you so much for your continued support. He say, look, hey, gorgeous sweet pea, Miles and chat fam, what's up? Oh, well, hey, Tanya, hey, Only, good morning, good morning. Oh, man, I tell you, if they telling you they want you for that, like almost what it is legal slavery. Man, you messed up out here. You can't win. You done out here. I don't even know what to tell you. Hey Denise, how are you? Hopefully I did miss anyone. Hey Debbie, how are you? Good morning. Yeah, that's what I heard. Somebody put a comment up on her and saying it was like, I don't know if y'all seen it, but I mean, let me show it to y'all because I mean, like, he was like the guy that was on there, the officer, man, he was almost like licking his chops, like his fingers about this. Like he was so excited to have that young boy, that young stallion come over there. He don't know what to do with himself. Let me show y'all. Just in case y'all didn't see it. Oh, I'll show y'all on break. That's okay. I'm gonna show y'all on break. Only because I see they getting started in court. I'll show y'all on break. But oh yeah. Hey Susie, you just got in here in time for the good mornings. Okay, let's get in here. Let's get it to these closing arguments. Get to our day. All right, Sweet Pea Gang. Let's get it. I think when I came in here earlier, look at him. I'll pull it forward. His old green self. He should have had his. I don't know what he was thinking. I'm gonna pull us forward so we can get right in there. I just wanted y'all to kind of like see their appearances this morning. How do y'all like Judge Cisco in this case? I'm gonna I'll put that in. That'll be our first survey. I think she was a lot better in this case.
It starts off. See, we start off.
She like let these gang members go. She want to know what they doing in Jacksonville and why they got all these issues. Let these young boys go on in there. They are not doing anything for this out here. Let me slow down the speed. Her face is oily today. The camera not hitting her well. Okay, they bringing the jury in. Here we go, guys.
Okay, very good. Welcome back, members of the jury. We are ready to proceed. And Ms. Finkelstein, on behalf of Sean Gathright, you may proceed.
Good morning. Members of the jury, we have come a long way since you were selected a little bit over 3 weeks ago. And now we have reached the most demanding part of this trial. In just a little while, the fate of Sean Gathright is going to be out of our hands and into yours. If you remember back to jury selection, there was a lot of numbers, scales, questions posed to you over and over. And I told you at that time I wasn't going to hold you to those numbers. Some of us said we didn't really like the numbers. It was just kind of getting a feel for where you guys stand coming into a new scenario. And the reason I said that was because this isn't a test. This isn't a numbers game. not a math problem or an equation. This is most literally a life or death scenario. Soon you will have to decide whether a young 20-year-old man will spend the rest of his life in prison or whether he will be executed. Sean Gathright is not wicked. Sean Gathright is not evil. No matter how many times, no matter how many ways it could be said in the state's closing, he's not a mastermind. He's not a super coordinator or orchestrator. Apparently, he might even be a rocket scientist. The state can minimize or diminish the mitigation list that's in front of you. The state may think that something deserves weight or no weight. That doesn't matter. That decision lies with each and every one of you. The state's opinion or theory is just that. This part of the trial, as I told you in opening, is about the defendants, about Sean Gathright, and it's about each one of you. On several occasions, I heard Mr. Harmon, when he was reading some of the mitigating factors that are on there, say, you can find that mitigating, that's fine. But lucky for you, you don't need permission. You can evaluate that mitigation exactly how you feel fit. Each and every one of them. This is your decision, a personal decision, and you never, under any circumstance, have to vote for death. In the state's close, Mr. Harmon presented a very strong case for why you should find Mr. Gathright guilty. You've already done that. That part's over. Went pretty hard on Mr. Gathright and painted him out as a person who led this whole thing. We wouldn't be here without him. That's his theory. And my theory is that's done to lessen the mitigation. That was done to convince you that what you saw and what you heard from this witness stand this last week from Mr. Gathwright's mouth himself shouldn't be given the significant weight that it deserves. But what it actually did was prove that a kid with no motive, no involvement, no history in that, can get wrapped up in a culture that he has no business in. The evidence was overwhelming that Mr. Gathwright's life has, and always will have value. Mr. Gathright is a human being worth saving, even in prison. People may think, well, you're in there for life or death. Does it matter? You're in there. Yes, because you heard from Mr. Bonasco all the different ways that you can be useful, not only to the state from a financial perspective, if that matters, but to other people in prison, out of prison, his family that supports him no matter what, sits in here and listens every day. You heard what a positive, optimistic person he is from friends, family, guidance counselors. He can be a light in a dark place. Hopefully he can keep making people smile. Even now, from jail, you heard that he's still asking about other people when he talks to them, trying to keep them in good spirits while he's sitting in jail. While he is facing a death sentence, he's worried about other people. That's not wicked. That's not evil. The theme from those witnesses on Mr. Gathwright's behalf, well, he was positive, he was funny, he was witty, he made people feel good. You heard that he was kind and respectful and well-mannered. And you don't just have to take the word of family and friends that know him and, of course, want to come in and they want to save him. They want to help him. You saw it from Mr. Gathright. That young man had the courage to get up there and face you and talk to you and try the best he could to explain his remorse, his accountability, and his worth. And when he was questioned on cross-examination and tried to get riled up, he remained respectful. That's his character. That wasn't a show. He was authentic. He was real. He was honest. He didn't get riled up. He answered every question politely, with sir at the end, from someone who was cross-examining him pretty harshly and was seeking to have you vote to take his life away. He remained respectful because that's who he is inside. That doesn't change. Now, is that the reason that you should not give somebody a death penalty? Well, that's up to you. And that's why it's your choice. But what it is, along with the other testimony you heard, is that proof that good kids, good people, privileged kids, I guess we want to call them, educated, intelligent, worldly, that those types of kids, Sean Gathright was not isolated or insulated or immune from getting wrapped up in something that he had no business in. He's an 18-year-old kid who is not immune from outside influence, curiosity. He told you himself, yes, I had a privileged life. I had people that loved me. I got to travel. I saw things. I did things. I had opportunity. And I still, after leaving that bubble, saw parts of Jacksonville, parts of a culture that I didn't know were out there. And look where he finds himself. That curiosity from that 18-year-old kid brought him right here. You know, the state said, oh, Mr. Bonasco, who testified, the prison expert, said Mr. Gathright was mature. I think everybody did. I think you can see it for yourself. He's mature. He appeared mature for his age. Well, Mr. Bonasco is basing that on a conversation at the jail for, I think it was a little over an hour. But either way, because he worked, traveled, helped support himself, cared for others, went to school, presented himself as grown, can take care of himself, that might be mature for an 18-year-old, but he's still 18. Maturity on the outside is not the same thing as being a developed adult and having life experiences, having knowledge, having street smarts. It's not the same thing. You can be well-spoken and smart and mature and still make really bad decisions. He is impressionable. He's naive. He was curious. He told you he was easily influenced. That matters. He told you himself that he was more vulnerable to influence and more likely to follow others, probably based on his lack of seeing other aspects of the culture, other aspects of Jacksonville. And we heard that it's pretty rough there. Because he was 18, he was less capable of kind of stopping and saying, wait, maybe this isn't taking me where I need to go, and seeing the end result. He doesn't have that experience or that knowledge. He told you that while he had male influences and guidance in his life, at the times that he felt it really mattered. When Brian Harrington, his stepfather, who was a great guy, divorced his mother 2020, Sean Gathright was only 15. So from 15 till he lands in jail at 18, he didn't have a steady, constant influence in his life when he needed it the most. He's not saying he didn't have anybody. He's not saying all the people that come here to support him and love him weren't really there. They were. But he's a kid. He's feeling his way through things. And it wasn't constant, and it wasn't there for him at those years. And that fact doesn't excuse any conduct. It doesn't remove accountability, but it explains how a young person with so much promise can make a catastrophic decision that could define the rest of his life. That one decision. And I told you in opening that mitigation isn't an excuse. I'm not up here to make excuses for Sean Gathright, and he wasn't making excuses for himself. He wasn't blaming anybody. It's an explanation, and it's a reason. And that's what mitigation is all about. It helps to understand what I'm sure everyone is wondering is how he got here. It's his story. He took accountability. He showed remorse. Remorse is defined as deep and painful and often long-lasting feelings of guilt, sadness, or regret for past wrongdoing. Not at the moment. Most people don't feel remorse while they're doing something wrong. They feel it afterwards, and that's what you saw. That wasn't contrived. That wasn't fake. That wasn't for your benefit. It took a lot for him to get up there, and he wanted to. Accountability is obligation or the willingness, which you saw, to accept responsibility and account for one's actions, and that's exactly what he did. He was straightforward. He was composed. He was wholly authentic. And he told you, what led him there, what his curiosity did to him. And you had heard from Maurice Edwards. The state tried to say, he never, one of the mitigators was about, him, his instability or not being able to adapt. And Maurice Edwards did tell you that at a younger age, being that he had some experiences and that Sean traveled and was not as steady in a place, he has a biracial family, that he did feel some sense of instability. Where do I belong? Where do I fit in? And of course you're traveling all over. Yes, you're seeing great things, but he's still a kid. And he admits, Mr. Gathright told you, step foot in the jail and immediately thought, where did my path veer? And instead of feeling sorry for himself, getting down on himself for this situation that he and nobody else that you heard from saw coming, he cracked his Bible. He told you he talked to God. And he's trying to make the best of a situation that he finds himself in. He said something that I thought was pretty profound, that he said, people are always asking God for something, praying to God to give them something or do something for them. And he thought, I can ask God what he wants from me. So even in this situation, he can be a light. He can help people. He can try and turn lives around for kids that he comes into contact with, or adults. In a dark, dark place, he sees hope. He sees a future. And I'm up here asking you to see that future for him. See the hope in him. See the redemption in him. A lot of the questions of our mitigation witnesses, and then some of the state's closing, was thinking, he's a privileged kid. He had it all. Does that mean he's not worth saving? I would submit to you that it's the absolute opposite. There's a long list of mitigating factors that you'll have in your instructions, and the state went over a lot of them. I think there's 32 for Mr. Gathright. I'm not going to read them all to you right now, but you'll have them when you deliberate. And it's a long list for a reason. It's a long list because in his short 20 years, 18 when this happened, he really made an impression on this world. So it's a long list. Imagine what he could have done if he had more than 18 years. And remember, that's just a list that we're providing you. Mitigation can be absolutely anything that you want. Anything you heard in the first phase, anything you heard in this phase, or just because you don't think that this young man deserves to die. The law says that you can find those aggravators that the state proved to you in the first phase, reminded you of yesterday. You can find that those were proven. You can find that they outweigh the mitigators, and you never have to sentence someone to death. The death penalty in this phase is not whether to punish, but how. It's not about whether Mr. Gathright will die in prison, but about when and by what means. Natural causes are at the hands of the government. The death penalty is not appropriate in this case. Mr. Gathright does not deserve the death penalty. This is the only time you have to make this decision. You can't change it tomorrow. You can't change it next week. This is it. A vote for life does not excuse any criminal behavior. It's not an excuse. It doesn't excuse responsibility for a crime. A vote for life doesn't diminish the life of Charles Jones or the loss to his family or his loved ones. A vote for life in this case is the just decision. It's the right decision for Mr. Gathright. Do not define Sean Gathright by the worst decision, the worst moment of his life. Sean Gathright is a son who's worth saving. He's a friend worth saving. He's a nephew worth saving. He's a grandson that's worth saving. He's a baby brother worth saving. He's an uncle worth saving. I'm asking you to do just that. Thank you.
All right, thank you, Mr. Petridis, on behalf of Isaiah Chance.
Please, the court. I want to thank you again. You're going to get a lot of thank yous today, and they're well deserved. We are at the end of your service, but as I said in my opening, we are also probably at the most difficult part of your service, and we all understand that. I want to start by saying justice will be served. Isaiah Chance will spend the rest of his life in prison, punished away from society. All we are asking is that you spare his life. Death is never required. The death penalty exists for the worst of the worst. We submit that Isaiah Chance is not that. As I said, he will pay for this crime every day for the rest of his life. We are asking you to let him have that life. This is going to be a conversation about life, a request on behalf of a young man and his family, Isaiah Chance, someone from Jacksonville, lived with his mother, who sat in his grandmother's lap, who called his father all the time, went to Atlanta to be with his grandparents. Man with 3 children. That's who you are deciding about today. Man who spent every day of his life working harder than those around him, just trying to keep up and working harder to make it seem like he wasn't doing that. You heard from 6 people and a doctor, 6 people who love him and a doctor from that chair, and they told you who he is. They're asking for you to believe them and to listen to them. The law gives you this phase of the trial for a reason. You have decided guilt. We are past that. It asks you to decide who Isaiah Chance is and who he is and how he got to be that, if he's worth saving. As Ms. Finkelstein said, mitigation does not excuse, mitigation explains. I'm asking you to look at Isaiah Chance, the full human being, and decide whether death is appropriate, if death is the answer. And death, we would argue, is never necessary. You heard from his entire family during the penalty phase. And like I said, a doctor, 7 different witnesses from 7 somewhat different vantage points, but all told you essentially the same thing. From Victoria Gray, she described his mother. She described him as quiet, gentle, close with his family, never violent. Someone who really didn't want to play football, who had goals, wanted to be a merchant seaman, an entrepreneur who was trying to build something. She told you him and his entire family had hobbies. I think she said martial arts that they would do together because they loved each other and they genuinely wanted and loved to be around each other. Think about her, what it takes to raise 6 children, not on her own, but in large part on her own in Jacksonville, and each one of them know that they are loved. Isaiah Chance clearly knew he was loved by his mother. He told you that himself through his interviews with the doctors, told you that by how he acted with his father, how he acted with his grandparents, how he acted with his children. He got that from his mother. She gave that to him. It didn't come from nowhere. You heard from Isaiah Chance Sr., a United States Marine who after serving came back to Jacksonville, who after getting divorced from his mother stayed in his child's life, stayed in Isaiah Chance's life. When he would help him with his schoolwork, he saw him struggling. And he said, hey, it reminded him of himself. You're like me. I struggled. Keep going. I see you. Not an excuse, but just, I see you work. I see you working. He told you something else. He said that Isaiah called him all the time. And every time he hung up the phone, he said the same thing beforehand. He said, I love you, to his dad. Every single time. Something so ingrained, it was subconscious or subconscious, but he said it. No one's listening when you're talking to your father on the phone. It's not performative. It's just something you do. And he decided at some point, like I said, maybe subconsciously, that every time he talked to his dad, he wanted to let his dad know that he loved him. That is not something, again, that he decided to do performatively. That just shows you that's him as a son. Heard from his grandmother, Elizabeth Jordan, Nana, I think she said. She said he used to sit in her lap when he was a baby, and if he could, he would do it today. She told you that her and Papa used to take the grandchildren on vacation and take them to church. They were there for the grandchildren, and when they needed Isaiah, he was there for them. She told you when Papa was sick, he was, I believe, 7 days he was in a coma. Isaiah Chance didn't call and see how he was doing. He didn't text and see how he was doing. He showed up. He stayed at the hospital until he woke up. And then when they needed someone, when Papa wanted to go home to be with his wife in Atlanta, she couldn't care for him on his own. They called Isaiah Chance, and he showed up time after time. I think it's like a 5-hour drive from Jacksonville to Atlanta. He made it over and over again for years to be with his grandparents, to help take his 260-pound grandfather out of bed when his grandmother couldn't, when he was 19, 20, and 21. When most kids are thinking only about themselves, Isaiah Chance realized that when family calls, you show up, and he did that. I think that's an important part of Isaiah Chance and who he is, someone with value. And I ask you to remember that as you deliberate. You heard from Michelle Smith, his godmother. Knew him, she said, before he was born. Had a good relationship with him. And she said she would always tell him the truth. That's AC kicking on, thankfully. She supported.
I'm sorry to interrupt you. It sounds like the AC has kicked on, and so Mr. Petraeus, just if you could try.
Yeah.
Just now, it sounds like a windstorm over there. So
it's a good thing, though.
Yes, it is a good thing.
You heard from Nashawn Nix, his former stepfather, his mentor. And he was someone I thought was a very important witness. He's not blood related to Isaiah Chance or his mother, obviously. Didn't have to be here. He was in Isaiah's life from 7 to 12, so a little while ago. And he built an organization whose entire purpose was identifying young men who can be reached and investing in them. And he saw many that couldn't be reached. And he showed up here. He told you when he was with Isaiah, he noticed things. He would go to school meetings. He would talk to him after school. He talked to his guidance counselor. He noticed things the family saw as well. was pushing for tutoring, for structure, and for support. And years later, after he was out of Isaiah's life, no longer with his mother, Isaiah Chance needed a letter of recommendation to be a merchant seaman. And he went to Mr. Nix. And Mr. Nix saw something in Isaiah Chance, and he put his reputation on the line, and he wrote that letter of recommendation for him. That's not obligation. That is not sentiment. It's a man who spent his career learning to see who people are, and he saw something in Isaiah Chance, and we're asking that you see the same thing. You heard from Miss Wade. She's known him from about when he was 16 years old to when he was becoming an adult. She said when she needed someone to house sit, when she needed someone to pet sit, and anyone who knows pets knows that that's a serious obligation, someone to let someone else watch their pet, she called Isaiah Chance. She never had any issues. She never had any trust issues. He did it every time. That's not someone you let do that unless you genuinely trust that nothing will happen. She told you he would talk to her about his plans for life, specific plans, his goals, what he wanted to accomplish. And she plans to stay in touch with him while he's in prison. Tells you everything about what kind of person inspires that kind of loyalty. 6 witnesses, 6 different relationships, telling you 6 different years of Isaiah Chance's life, different eras, all telling you the same thing. He was quiet, respectful, gentle, loving, nonviolent. A young man who needed a little more structure than the world gives to most people. Then there's the science. Dr. Tracy Hardig, forensic psychologist. She spent hours with Isaiah Chance. She did actual IQ and academic testing. She reviewed school records going back to when he was in preschool. But before that, let's talk about what she said when she noticed him. He was quiet. He was mild-mannered. He wanted to be there. He wanted to do the tests. He was not depressed. And he kept saying the same thing essentially throughout the testing. I'm smart. I know I didn't do great in school, but he wanted to impress her. And he used some big words, and I would say he used some correctly and some incorrectly, like he did with Dr. Werner. He got a full-scale IQ of 71. That's what she got through the testing. At age 22, he reads at a 5th grade level. His math is at a 3rd grade level. The things that a lot of us take for granted in life that we get through life are genuinely harder for Isaiah Chance. Not impossible, just harder. She reviewed his Duval County school records, which I believe Dr. Werner glossed over. He had 3 tests done in school, and they all said the same thing at ages 4, ages 10, and ages 12. 3 different other evaluators, independent. At age 4, said he had issues with speaking, and we heard from multiple of his witnesses telling you that he was nonverbal at that time. So corroboration. At age 10, he got the same score as Dr. Hardig got, corroboration. And at age 12, he was even a little bit lower again. And then he's removed from that school. People with IQs in this range are not unintelligent. They can form relationships. They can have jobs. We're not asking you to weigh his IQ as an excuse, but just as context, something you can weigh when you're back there deliberating on mitigation. She also diagnosed ADHD, and the clinical observations you saw from school showed the same thing. Off task over 30% of the time, way more than his classmates, and it was never treated. The state talked about a co-defendant not having IQ tests because they didn't provide corroboration, and they talked about that as a bad thing. Well, we have corroboration from 3 IQ tests, and they don't want you to look at that, and I'm asking you to look at those IQ tests that corroborate Dr. Hardig's and go against what Dr. Werner said. And the last thing I want to say about Dr. Werner is she said that she trusted the testing that was done in school, trusted the testing that Dr. Hardig did, trusted and agreed with the results of both, but disagreed with the diagnosis, which is based on the results. And I would say that doesn't follow. We also heard that he could be vulnerable in the wrong environment. He has a lifelong need to belong. And that's a human, that's a character, it's not a character flaw, it's just a human need. But I want to talk about what the right environment looked like. That looked like what Mr. Nix provided. When Mr. Nix was there, when he provided structure, when someone was paying attention, made real progress. Isaiah made real progress. It tells you something. Isaiah Chance is not someone who's beyond reach. He's someone who does better when someone is paying attention. We're not here to ask you to believe that he will never struggle again. We're asking you to believe that struggle will be worth it, that he has value, that it matters, that he is not what happened in the worst moments of his life. Now, the state pointed to the aggravators. They spent a lot of time on the aggravators, and we're not here to minimize what happened, not at all. We're not here to argue those either. We're here to talk about this young man, him as a human being, about things that make his life worth saving. We're here to tell you we believe the mitigators outweigh the aggravators. Like Ms. Finkelstein said, you're going to get a list of the mitigators. I'm not going to go through all of them. I do want to go through a few of them. And you give whatever weight you believe to these mitigators. Isaiah Chance has no significant history of prior criminal activity. You heard from his mom and his dad, no arrests, nothing. His age at the time of the crime, he was 21 years old at the time of this crime. He was a young man. Like I said, he suffers from borderline intellectual disability and untreated ADHD. His loving relationship with his children, which I'll get into in a little bit. His loving relationship that you heard from his family and friends that goes both ways. Isaiah Chance did not carry, use, or threaten to use a firearm during the commission of this offense. Let me be clear, this in no way lessens his guilt, but it is a fact that you can consider when you're back there, that he did not have a firearm during this offense. And again, there's the catch-all. Anything else you heard from any witness on that stand that you saw, you believe is a mitigator you can use. Isaiah Chance is a son, a brother, a grandson, and father whose life has meaning to others. His children, Kabri, Kylan, and Amiri. His mom told you he was a great father. He wanted to be involved with his kids. Miss Wade told you he was always calling her, asking her for advice. He wanted to be involved. He was present. He was trying to be a good father. He was 21 years old with 3 kids, actively seeking out guidance to be a better father. That is not the behavior of someone who doesn't care. That is behavior of a young man who understood that fatherhood mattered and was trying imperfectly to rise to it. He cherishes fatherhood and has a great relationship with his 3 children. That is not nothing. For a 21-year-old who may have some limitations, trying to figure out how to be present for 3 children, that effort means something. It tells you something about who he is when the stakes are personal. He showed up for his children, just like he showed up for his grandparents. It's not a legal argument. It's a fact about what it means to be human. His kids are growing up right now. One day they will be old enough to know their father, to write him a letter, to ask him a question only he can answer. And he will be in prison. But a father can still be a father behind bars. A letter, a phone call, a presence. We are simply asking for you to leave that door open. 7 people testified in the penalty phase. 6 who have known him parts or all of his life, and a doctor. Dr. Hardy told you the clinical side. People like Isaiah are a little more vulnerable. They want to belong. They want to follow because it's safer than the alternative. He spent his entire life working harder than other people, failing and trying again. He put his family first and truly sacrificed on multiple occasions when it mattered. He sat in church with Nana and Mr. Nix and talked about God and life. He was a great brother and a great and attentive father. He's someone's son, someone's grandson, someone's father. He's a human being with limitations and with love. You heard about the continued support he will get while in prison. On behalf of his mother, who raised him with structure and love, his father, who was there for his son and still wants to be there for his son, Elizabeth Jordan, who he sat in her lap his entire life, and Nashawn Nix, a man who owes him nothing but showed up here to tell you that he loves him, and he better know that he still loves him. We are asking you to spare his life. The family did not need to come here. They chose to. They sat in the witness chair knowing everything that you know, and they want to tell you that this person is not beyond saving. They're not in denial. They know what happened. They still came here and they're still asking. That says something about Isaiah Chance that no test score or school record can fully capture. It tells you the people who know him best, who have seen every version of him, have decided he's worth fighting for. And we are asking you to agree with them. The death penalty is reserved for the worst of the worst. We would argue that Isaiah Chance and the facts of this case do not meet that criteria. He's not the kind of person for whom there's no threat of redemption or no evident conscience that the death penalty was designed for. Death is never required. Again, as I say in my opening, the law favors life because it always gives you the opportunity to give mercy. We are asking you to consider that a person can do something unforgivable and still not be beyond the reach of mercy. Isaiah Chance will spend the rest of his life in prison. He will carry what happened to him every day. We are not asking for you to forgive what happened. We are not asking you to forget it, minimize it, or look away. We're asking you to look at the full human being, everything I've talked about and everything you've heard from the stand, and decide that death is not the answer. Justice will be served. He will spend his life in prison. Today's the last day he's going to wear street clothes. Last time we'll put a suit on. Mercy does not mean forgetting. Mercy means choosing deliberately and with full knowledge what you know to let someone live. The law gives you that option, gives you the option for a reason. We are asking that you use it. We are asking that you spare Isaiah Chance's life. Thank you.
Okay, very good. Ms. Timmy, on behalf of Davion Murphy.
Okay. 1997. A blank canvas, wide-eyed to the world, not knowing his limitations, not knowing good from bad. But children learn what they see every day. When children learn criticism, they learn to condemn. When they learn hostility and violence, they become violent and fight. When children live with instability, they become unstable. Now, as I told you in my opening, Florida has no parole. There's no gain time. As Davion Murphy sits there now, and all of these other defendants, they will be given life in prison. The only question for you is when he dies, either by natural causes or by execution. That's the only decision that is left to make. And this is probably the most important decision that you will make in your life. The fate of another human being is in your hands. I want to pose a question to you, and that is, what good comes from executing Davion Murphy? Seems like a simple question. It's not so simple. I think it was Gandhi that said, an eye for an eye eventually leaves everyone blind. There is no need to execute Davion Murphy. Life in prison, a life, along with thinking about this every single day. Perhaps even maybe walking down the same hallway as his father, stomping the same concrete in those hallways in the Florida Department of Corrections as his father, his uncle, his younger brother that testified, his blood cousin, Rashad Murphy. A vote of death will only be the next statistic in this gang war that started in Jacksonville. It'll be just another statistic. And what comes from executing another human being? Nothing comes from it. It's not going to bring Charles Jones back. It's not going to change the events that occurred on June 23rd of 2023. It simply perpetuates the violence that started long, long ago, not here in Hillsborough County, but in Jacksonville. As you heard from the state's witnesses, the detectives, the gang detectives, so much violence so in these gangs that they have detectives that are given certain gangs to follow. That's what Davion Murphy grew up in. He grew up in East Jacksonville. Davion Murphy wasn't born into a life of privilege and opportunity. He was born into violence and instability. What chance did he have? And folks, I'm not offering you an excuse for these events or what happened. It's tragic. I'm simply offering you context of the facts. Context. Davion Murphy was 12 years old when his father, who suffered from schizophrenia, was given life in prison for murder, along with his uncle, his parental uncle, who also was given 50 years in prison for murder. When he was 12 years old, his father was gone, absent from his life. And you heard from his youngest brother, Adam Gooden, his youngest brother, who broke down in front of you all. Well, they grew up in the same environment. They had the same mother. They had different fathers. But if you recall, Adam Gooden also told you that his father was incarcerated in prison. This is a generational violence, instability, insecurity that these men grew up in. When I say these men, I mean Davion and his cousin. And you got to see this firsthand through the state's witnesses, their detectives, as well as through the individuals that testified on Davion's behalf. Take a technically, intellectually disabled child with learning disabilities, throw him into the violence and crime in the streets of Jacksonville. What happens? They look for comfort. They look for a father figure. What becomes the father figure for them? The streets, the gangs. Now, as you saw, not only did Dr. Eisenstein, and we'll get to that in a moment, but Dr. Eisenstein testified that he was borderline intellectually disabled. They had long ago indicated that Davion Murphy had a mental disability. He was in special classes. He was in IEP classes. He had to repeat various grades. And he also suffered traumatic brain injury from all the various events that occurred in his life. Multiple motor vehicle accidents, fights, falling off a golf cart, or running a golf cart into a tree. And folks, these scans, these images weren't done because he was found guilty. The state knows better than that.
Judge, objection, that's an improper statement. It's a misstatement of the law, and that's improper.
I'm going to sustain the objection.
These scans were done to show you that Davion Murphy suffers brain damage. What does Dr. Rubino have to come in here to risk his medical license to say, and you saw the scans, and you can take it back if you want to look at them, to say that he suffers from brain damage? And the state had its not an MRI, DTI, which is commonly done in these radiology facilities. Why would a neuropsychologist recommend scans that a neurologist send to a radiology facility that then conducts the scans and gets those images, perform those? It's a big liability there. I suggest to you that he does have brain damage. You can watch the interrogation video yourself. That's demonstrative evidence of the state of mind of Davion Murphy and his intellect. Now let's talk about a little bit about mitigation. As you've heard, it's not a numbers game. It's not a calculation. It's not who's got more mitigation. It's about the weight and the significance of that mitigation. I'm not going to address the aggravating factors. I'm not going to waste your time. I'm not going to insult any one of you. But the mitigation that was presented on behalf of Davion Murphy is substantial and is great, and it deserves great weight. And you also have to remember that the mitigating circumstances have to be proven, not beyond a reasonable doubt, but by a preponderance of the evidence. I submit to you that Dr. Eisenstein, who met with Davion Murphy 7 times in person over the course of 6 months for over 20 hours, has a better idea, a better understanding of what Davion Murphy is about, not Dr. Warner, who met with him by Zoom for 80 minutes. And then when asked by the state about why she had such limited time, was because the jail only gave her 3 hours or something like that. Well, if you only had 3 hours, then say you need enough time. You didn't have enough time. You can't render a proper diagnosis or render an opinion because you didn't have enough time. Dr. Eisenstein had enough time. He took the time to know Davion Murphy, went through his records, his medical records. And why did we not provide Dr. Eisenstein with police reports, videotape interrogation videos and such? Because we wanted to make sure that there was no bias, that Dr. Eisenstein met with Davion Murphy, without any bias in his mind. That's why. I suggest to you that is the aggravation. Is going Does it matter? Does it matter if you've got but by a preponderance of the evidence. I submit to you that Dr. Eisenstein, who met with Davion Murphy 7 times in person over the course of 6 months for over 20 hours, has a better idea, better understanding of what Davion Murphy is about, not Dr. Warner, who met with him by Zoom for 80 minutes. And then when asked by the state about why she had such limited time, was because the jail only gave her 3 hours or something like that. Well, if you only had 3 hours, then say you need enough time. You didn't have enough time. You can't render a proper diagnosis or render an opinion because you didn't have enough time. Dr. Eisenstein had enough time. He took the time to know Davion Murphy, went through his records, his medical records. And why did we not provide Dr. Eisenstein with police reports, videotape interrogation, videos and such? Because we wanted to make sure that there was no bias, that Dr. Eisenstein met with Davion Murphy, without any bias in his mind. That's why. I suggest to you that Davion Murphy's life is worthy. Davion Murphy is worthy. That he is redeemable. That he's made a grievous mistake and that he should be punished. He will be punished. He's being punished every day. And he will be punished every day for the rest of his life. There's no doubt. But it's your job to look at him as an individual, all of these defendants as individuals, and not compare one to the other, but look at each of them as an individual person, and then decide whether the mitigation, which has a lower burden, and rightfully so, has been proven in substantially or outweighs the aggravation in this case. It has to make the crime more grievous. It doesn't. Life is the appropriate sentence. There's nothing that a death sentence is going to do in this case. So the mitigators that you have on behalf of Davion Murphy is the capacity of Davion Murphy to appreciate the criminality of his conduct or conform his conduct to the requirements of law. That's one. He's got 13, but once again, it doesn't matter. It doesn't matter if you've got 50 or if you've got 100 and it's not a numbers game. It's not who's got more or who's got more aggravators versus mitigators. The second one, the capital felony was committed while Davion Murphy was under the influence of extreme mental and emotional disturbance. That's where Dr. Eisenstein comes in. That's where Dr. Rubino comes in, their testimony. The age of Davion Murphy. He was 27, but when you consider the testimony of Dr. Eisenstein, the age of the person on the outside isn't necessarily the age of the person on the inside. Davion Murphy suffers from traumatic brain injury. Yes, Dr. Rubino testified that he did. And doctors, they disagree. They do disagree. You have to decide who you believe. And once again, we don't have to prove beyond a reasonable doubt that these mitigators exist. Just a preponderance of the evidence. greater weight of the evidence. Davion Murphy is in the borderline range of intellectual disability. Let's talk about Dr. Warner for a minute. She indicated it was low average, I think is what she testified to. But she's doesn't have the ability to do any psychological testing, didn't do an IQ test, didn't do really basically anything. She did a mental status examination of Davion Murphy. That was not rebutted, wasn't disproved. Davion Murphy did not have a stable role model in his life. No, he did not. Neither did his younger brother. Davion Murphy's father was diagnosed with schizophrenia. Yes, you heard from Winston Murphy, who was very reluctant to testify, but yes, that was his brother, and he testified that his brother, who was Davion Murphy's father, was diagnosed with schizophrenia. Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. Yes. Davion Murphy took on a parental role for his younger siblings. Yes, because he had to. Adam Gooden testified that he had to sell, or they would sell a PlayStation or something like that to get food. Davion Murphy is loved by his family. Yes, yes he is. And then the existence of anything else. That means that mitigation to you can be anything else that you decide it to be. You get to decide. Maybe it's something I didn't say or wasn't presented to you. Maybe it's something that just because you think life is more appropriate than death, than execution. Because this vote is individual to each one of you. It's an individual moral judgment that each one of you have. Yes, you have to go back and discuss the evidence and things, but it's your vote. It's not anyone's vote. And don't let anyone else try and convince you of what your vote should be when you go back there. It's your decision. Folks, gang violence tears apart families, neighborhoods, and futures. And that's exactly what it did with all these families, Charles Jones' family. The death penalty only guarantees that suffering and that violence continues. Life in prison for Davion is a just punishment. It removes him from society. And we can be tough on crime without the death penalty and just giving him life in prison. Now, this is the verdict form. And once again, just like in the guilt phase, excuse me, just like in the guilt phase, just because you didn't hear from Davion Murphy, like you heard from Sean Gathright in the penalty phase, doesn't mean you can hold that against him. He's got the right to remain silent, and you cannot use that against him. Just want to remind you of that for any of the defendants that did not testify in the penalty phase. But here's the verdict form. It's 3 pages long, but on that second page is where it has jury recommendation. And you might think, well, it's just a recommendation. It is, but your recommendation will be given great weight by the court. So when you vote, it's going to be the vote. It's going to be the deciding factor as to what these individuals get, life or death. If fewer than 8 jurors vote for the death penalty, your recommendation must be for the penalty of life in prison without the possibility of parole. Fewer than 8. That means 7 of you can vote for death, 5 of you can vote for life, and they will get life. I submit to you that you really don't need to even get there, folks, because you could just go right to the bottom and find that Davion Murphy should be sentenced to life in prison without the possibility of parole. That is a just punishment in this case. This is not the most aggravated of murders and the least mitigated. What good would it do to execute an intellectually challenged, brain damaged 29-year-old male who's grown up on the streets of Jacksonville just trying to survive the gangs and the violence? He lived and did what he saw every single day. He's going to be punished enough. You can tell Davion Murphy that he did a terrible thing. This is terrible. It's tragic. But you can also tell him that he's redeemable and he has worth with a vote for life. Thank you.
Thank you, Ms. Jimmy. And Mr. Hernandez, on behalf of Rashad Murphy.
Please,
Yes.
counsel. Good morning, ladies and gentlemen. I want to begin again by thanking you very much for your service, your attentive service in this case. As you know, I am speaking on behalf of Rashad Murphy. I cannot imagine an attorney having a more overwhelming responsibility than advocating for a man's life. And here we are. As we go through the evidence that was presented and the mitigating circumstances that have been proposed, I want to make sure that there is no attempt to misstate. If I say something, I've got notes, you have your notes. If I say something that you remember differently, please rely on your notes and your collective memories. You've heard it several times during this case, and I'll go briefly through it. Your recommendation is extremely important. It carries great weight. The judge has to give it great weight. And the mitigating circumstances that have been proposed by Rashad Murphy and the other defendants only have to be proven by the greater weight of the evidence. If you believe that it more than likely exists, you can consider it and give it the weight that you decide it deserves. And those mitigating circumstances can be facts about the case, or it can be facts related to Rashad Murphy as a person, as a human being, such as the mental issues that have been presented, his childhood, his history, his accomplishments. It can also be your personal observations of Mr. Murphy's behavior during the last 6 weeks, as you've had a chance to observe him for 6 consecutive weeks. And your vote, although you deliberate, each vote is individual. And although there is a weighing process, you ultimately are being asked to decide what is the appropriate vote, either a life recommendation without the possibility of parole or death. Ladies and gentlemen, nothing that I am saying during my closing arguments is designed to in any way minimize the tragedy for Charles Jones and his family. Death resulted regardless of the details. His family, the family of Mr. Jones, grieves regardless of the details. All that is a given before your analysis in this penalty phase begins. And the same principle applies to the crime of murder. All murders involve some level of violence, some less, some more, but they all involve some level of violence. All first-degree murders involve either premeditation or while committing a serious crime such as robbery or rape. Nevertheless, and that's why we're here, nevertheless, not all first-degree murders warrant the death penalty. And I submit to you that in the case of Rashad Murphy, the death penalty is not warranted. But we need an analysis of the facts of the case, but also of the person who Rashad Murphy is. You heard from several family members. You heard from his fiance, Charmaine Staker, and the mother, his fiance, that they've known each other for, I believe, 15 or more years, and the mother of his 4 children. You also heard from 2 of his aunts, Hazel Dickerson and Jamila Murphy, as well as his uncle who's in prison, who testified here as well, Winston Murphy. They all made it clear to you that they love him very much and that he has a lot of redeeming qualities. They all confirmed in one way or the other, they all confirmed Mr. Murphy's difficult childhood, his personal history, being an excellent father and brother to his siblings. They all had some knowledge, some more, some less, of the physical and emotional abuse that Rashad Murphy suffered growing up, that he witnessed gun violence and lived in a high crime area, that he was raising 6 children when he was arrested in this case, his 4 children and 2 of his younger siblings. Despite working and having a limited income, he was raising 6 children. You heard that he was consistently employed, and that you also heard from Ms. Steger, his aunts, that they would continue to have contact with Mr. Murphy and visit him in prison as he would be serving if he ultimately gets a life sentence without the possibility of parole. And with something that Mr. Harmon said yesterday, I want to make it clear, and I think you would agree. The fact that he has some loving family members, such as his fiance, but going back to his childhood, having 2 loving aunts, does not in any way erase the extremely difficult childhood that he had without a father and with a mother with a serious drug problem. And obviously, he was taken out of the family home and placed into foster care because of that. You also heard from Dr. Collins, a licensed psychologist. He testified and has previously testified as an expert in neuropsychology. He was appointed by the court and paid by the state of Florida. He was asked by me to evaluate the defendant, Mr. Murphy, and possibly testify in this case, which he did, obviously. Before he testified, he was provided reports, not everything in the case, but provided records to review. Some about the case itself, so that he would have a sufficient amount to become familiar with the facts of the case and the evidence in the case, but also about the defendant before he even sees the defendant at the jail, things that would give him knowledge of the defendant as a person, his background, his childhood history, his mental history, jail records, because by that time he's been in jail on this case for a period of time. And then he has contact with the defendant on 2 occasions. I believe his testimony that he ultimately spent a total of 7 hours with Mr. Murphy. Part of that contact is to interview him, just chit chat, have a conversation with him. And the purpose of that is to get to know him, to find out, to determine whether he is going to be cooperative and whether he is going to provide truthful information, because whatever he says can be compared to records that he's had a chance to review. And then part of that time is to conduct psychological testing, standard accepted test to analyze and diagnose. Dr. Collins testified, and none of this really is being refuted by the state. He was cooperative. There were tests done to find out if he was in any way faking and malingering. That was not the case. He was definitely cooperative and not malingering. The important thing, or at least one of the important things, is that the interview, the testing, and the records that were reviewed by Dr. Collins were all consistent, clearly indicating that Mr. Murphy was being truthful regarding his self-reporting about his childhood, about his background, about his history, and about his mental state. Dr. Collins testified that Rashad Murphy suffers from anxiety and depression stemming from childhood trauma that would be intensified throughout his adulthood. That Rashad Murphy, was physically and emotionally abused by his father, by his stepfather, and in the foster home. And that his mother suffered from severe drug addiction and ultimately died, where leaving Mr. Murphy with having to, by this time, he's of course out of the foster home and having to take care of his younger siblings. Dr. Collins confirmed that drugs and violence were common in his community, in the community that Rashad Murphy grew up in when he was not in foster home. Ladies and gentlemen, I'm trying not to be repetitious, but the fact is that Rashad Murphy was born into violence and suffered a lot of abuse and neglect. He was removed from his father's care by the state when he was a small child. And all of this is confirmed by Dr. Collins, not just talking to Rashad Murphy, but looking at all the records. And then, as I said a minute ago, is that back after, I think it was 2018, when his mother died, he adopted his younger siblings. He was employed, but obviously a limited income, trying to not only financially support his fiance, his 4 children, but also his 2 younger siblings. Dr. Collins also confirmed other records, and of course you heard from Ms. Steger, that he had a loving relationship with his childhood sweetheart and mother of his 4 children, that he was an excellent father, hard worker throughout his adulthood. The diagnosis by Dr. Collins is that Mr. Murphy suffers from post-traumatic stress disorder, PTSD. And as you know, it's a mental condition triggered by experiencing and or witnessing terrifying events. And it disrupts daily life. It affects his judgment, his decision-making as an adult. And it goes back to his childhood. Once someone has PTSD, it doesn't magically go away. It can be treated with psychotherapy and medication, but his condition is always there and does not go away, and it relates back to his childhood. And again, I should point out that, and I'll get to it in a minute, that Mr. Harmon in cross-examination, I think, tried to discount it somewhat, but there was never anything presented by the state refuting this diagnosis. There was also the fact that his father, Rashad's father, had mental problems. That was documented. And also that Mr. Murphy's condition was noted in the jail records by state doctors before Dr. Collins even got involved. So you have corroboration that is and not disputed by the state, discounted, but not disputed. There's no expert saying otherwise. You also, through the testimony of Dr. Collins, you heard that several examples of Mr. Rashad Murphy trying to help himself, better himself as a person while in prison. Ladies and gentlemen, that evidence has more than one indication. I suggest to you that it does show that he's trying to better himself as a person, but it also shows that it's indicative of him not being a troublemaker, adapting to prison life, following strict rules and regulations, that if he was sentenced to life in prison without the possibility of parole, he would not be a problem, a troublemaker in prison. He's been in jail 2 years without any problems. And as I said, trying to better himself, you have the exhibits that you can look at when you go back to deliberate. There were 3 composite exhibits presented to you. One is Defense Exhibit 1 dealt with education. He got his GED while in prison, while in jail, not prison. He got his GED while incarcerated on this case. He also, there's a series, Defense Exhibit number 2 has a several, I forget how many, 8 or 9 attached to that exhibit about different religious certificates and classes that he's attended, different religions, just showing religious awareness. But it also was presented during the testimony that he not only has been taking these classes, he has been teaching some of these classes to other inmates. He serves as a mentor in prison, in jail. I keep saying, I don't mean to say prison, Hillsborough County Jail. And then Defense Exhibit number 3 is a composite of certificates dealing generally with self-help, parenting classes, dealing with Alcoholics Anonymous, emotional regulation, things of that nature. And ladies and gentlemen, I think what I'm saying, it feels it's too obvious to mention. None of this testimony and exhibits are offered as legal defenses or excuses for the homicide. But as you know, all first-degree murders are inexcusable, but they certainly are offered as valid mitigating circumstances, showing that the defendant, Rashad Murphy, has many redeeming values, showing that a life recommendation is appropriate. The court, when we get to part of the instructions, when we get to specifically Rashad Murphy, the defense is offered to you a series of proposed mitigating circumstances, and that they will be read to you. One of them, and I think there's a couple that have to do with the fact that he has no prior criminal history, and we'll talk about that in a minute. No prior felony convictions. There's also a couple, they're kind of interchangeable, that Rashad Murphy, his age at the time of the offense, he was only 30 years old when the homicide occurred. There's no dispute of this. It's there for your consideration. The state never is not disputing it. It was stipulated to. Another proposed mitigator is Rashad Murphy has a history of physical and emotional abuse as a child consistent with childhood post-traumatic stress disorder. You heard from Dr. Collins, you heard from the record from the jail doctors. I think there's certainly corroboration of that, and again, something that has not been refuted by the state. You will also hear that Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. And again, you heard that from the fiance, Ms. Steger, his uncle, and his aunts. Another proposed mitigator is that Rashad Murphy has developed religious and spiritual awareness while incarcerated. In fact, you heard testimony that he was religious before, but certainly the exhibits and his family's testimony corroborate that. Also, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide family support. Certainly that was corroborated by the records and by the testimony of his family. And the same thing with the next one, which is Rashad Murphy as a minor was removed from his primary home and placed into foster care due to negligent and abusive situations in the primary home. Also, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. And again, that's corroborated not just by the exhibits and the records. He has been no problem whatsoever while he's been incarcerated. And that's an indication of what type of prisoner he would be if he is sent to prison for life. You also are being told the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death sentence. And we'll get to, I will touch base on some of these mitigators, but if there's something I forgot, something that you believe in your observations or hearing, please rely on that as well. Now let's go back to some of these. His age, which is two of the proposed mitigating circumstances. He was 30 years old at the time of the homicide. He's presently 32 years of age. To some extent, I would suggest that that age is an interesting number. He's still a young man. He's still a young man. He was only 30 at the time of the offense. And it certainly, that alone is offered as a significant mitigating circumstance. However, it also is old enough to have established a pattern, good or bad. It's certainly at the age of 30, you've been an adult for 12 years. It's certainly old enough to have become a career offender. But here we have no felony convictions whatsoever. So here we have 12 years of adulthood to look at, and we have a good pattern. with his background and an environment, with the violence surrounding him, with the abuse inflicted on him, I suggest to you that it's extraordinary that he made it to the age of 30 with no criminal history. Let's go back a minute to the PTSD. As I said before, the state is not refusing the mental condition. No state doctor testified saying, refuting the opinion of Dr. Collins. I think it's fair to say that the state is suggesting that considering everything, it's not important because you found the defendant guilty of first-degree murder. And as I said before, it's not offered as a defense, but it is presented to you as a significant mitigating circumstance for your consideration. And I think it's somewhat disingenuous for the state in their cross-examination to imply that the defendant's mental condition is normal for someone who's incarcerated. Of course, being in jail, getting arrested, got to be stressful. But that's not what we have here. The defendant's childhood is not normal. Getting abused by his father and stepfather is not normal, ladies and gentlemen. Growing up in the violent environment is not normal. Being abused at the foster home is not normal. Neglect due to his mother's addiction is not normal. Touching back briefly on his behavior while he's been in jail on this case. And as I said, it shows that he knows he's not he doesn't cause trouble at the jail. But I think it should be emphasized that he can be, in addition to having contact with his family, he can be a positive influence on other prisoners. He's been teaching Bible classes. He can mentor other inmates now in jail and later in prison. And as I said, he would, as you've heard testimony, the evidence has shown and his behavior has shown that he would continue to be able to maintain a living relationship with his family and friends while in prison. Ladies and gentlemen of the jury, all first-degree murders are not the same. That's just the bottom line. And that's a decision, a vote that you have to consider. The facts and circumstances are always different. All defendants convicted of first-degree murder are not the same. And of course, as a corollary to that, not all first-degree murders warrant a death sentence. I suggest to you that the death sentence should be reserved for the worst cases. All murders involve the death of a human being. All murders involve some level of violence. But here we don't have any torture. We don't have multiple deaths. Here we don't have separate incidents. It was all one event, a terrible event. I mean, there's no way to describe it otherwise. A terrible event, but only one contemporaneous event. You determined justice. You determined justice was served with your verdict. As you've been told more than once, Rashad Murphy will die in prison regardless of your vote. And based on your verdict, a severe punishment is appropriate, and there's only two choices. I submit to you that justice will be served. It will be further served by severely punishing Rashad Murphy by making him spend the rest of his life, which according to normal life expectancy could be another 50 years, to spend the rest of his life in prison, to live under strict rules and regulations without the basic freedoms we normally take for granted, that we normally enjoy. And I'm trying not to be repetitious, but I need to go back for a moment to this lack of any prior felony convictions. I cannot, ladies and gentlemen, I cannot overemphasize this. Despite the terrible environment the defendant grew up in, despite those scars, despite the mental ill issues he lives with on a daily basis and will continue to live with, despite whatever treatment he gets, the defendant, Rashad Murphy, has no prior felony convictions, not one. And I ask you, when you decide on your vote, compare that fact, that stipulated fact, to a career offender. Compare that fact to someone who has a prior record of similar crimes or violent behavior. Compare that stipulated fact to the state's argument that the attempted murders serve as an aggravating factor, despite being only one contemporaneous event. Compare that stipulated fact to the state's argument that an aggravating factor is that the defendant was a criminal gang member. All that, all those allegations, all those factors, despite the fact that he has no prior felony convictions. I submit to you that the mitigating circumstances outweigh any aggravating factors presented by the state. But in any event, I submit the mitigating factors clearly show that a life recommendation is warranted with respect to Rashad Murphy. Ladies and gentlemen of the jury, I have not offered this evidence or made this closing argument to in any way justify the homicide. My only point is that the evidence presented, all corroborated, demonstrates that a life recommendation is appropriate for Rashad Murphy. And finally, I want to talk about Rashad Murphy's children. 2 sons, 2 daughters, between the ages of 7 and 13. Pretty much the ages that the defendant was when he was experiencing some of this abuse and separation from his family growing up. Despite being in prison for the rest of his life, he was an excellent father, he is an excellent father, and he can still be a positive influence on his children. He has been and would continue to be a loving and supportive father. Please let him carry on as daddy to Major, to Avery, to Prosper and Gabrielle, guiding them to do the right thing. Thank you.
All right, thank you, Mr. Hernandez. Okay, we're going to take just a quick comfort break, and then we're going to come back. I'm going to read the final set of instructions to you, okay? All right, thank you.
All right. job, Judge.
Okay, very good. All right, take a 2-minute break and
All rise, doors enter.
okay, very good. All right. I believe you all should each have a set of the final instructions before you, so you can read along while I read them to you. Members of the jury, you have heard all the evidence and the arguments of counsel. Now you must decide whether each of these defendants should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state as to defendant Isaiah Chance are: number one, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Number two, the first-degree murder was committed by a criminal gang member. The aggravating factors alleged by the state as to defendant Sean Gathright are: one, Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. 2, Sean Gathright knowingly created a great risk of death to many persons. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions are the same with regards to cold, calculated, premeditated, and pretense of moral or legal justification. The aggravating factors alleged by the state as to defendant Rashad Murphy are: number one, Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Number two, Rashad Murphy knowingly created a great risk of death to many persons. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions of cold, calculated, premeditated, and pretense of moral or legal justification are the same. Number 4, the first-degree murder was committed by a criminal gang member. The aggravating factors alleged by the state as to defendant Davion Murphy are: number 1, Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. 2. Davion Murphy knowingly created a great risk of death to many persons. 3. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions of cold, calculated, premeditated, and pretense of moral or legal justification are the same. Number 4, the first-degree murder was committed by a criminal gang member. You have heard evidence about the impact of this murder on the family of Charles Jones. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by the death of Charles Jones. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each of the alleged aggravating factors exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt as to a defendant, then that defendant is not eligible for the death penalty, and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt as to a defendant, then that defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of a defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is a defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, a defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether a defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are mitigating circumstances as to defendant Isaiah Chance. Number 1, Isaiah Chance's age at the time of the offense. 2, Isaiah Chance has no significant history of prior criminal activity. 3, Isaiah Chance was 21 years old at the time of the offense. 4, Isaiah Chance suffers from borderline intellectual disability as well as untreated attention deficit hyperactivity disorder, also known as ADHD. 5, Isaiah Chance's decision-making was impaired by his borderline intellectual disability and ADHD. 6, Isaiah Chance did not personally carry, display, use, threaten to use, or attempt to use a firearm during the commission of the offense. 7, prior to this case, Isaiah Chance had never been arrested. 8, Isaiah Chance cherishes fatherhood and has a great relationship with his 3 children. 9, Isaiah Chance has a loving and very close relationship with his parents, siblings, grandmother, and godmother. 10, Isaiah Chance helped his grandfather and grandmother when his grandfather had cancer. 11, Isaiah Chance attended church with his stepfather and his grandmother. 12, Isaiah Chance helped his mother around the house. 13, Isaiah Chance was motivated and preparing for a career as a merchant seaman. 14, Isaiah Chance was described as a quiet, respectful, and nonviolent child by family members and friends. 15, Isaiah Chance has the continued support of many family members and friends. 16, Isaiah Chance is a son, brother, grandson, and father whose life has meaning to others. 17, Isaiah Chance is capable of growth, redemption, and maturity because of his young age. 18, the existence of any other factors in Isaiah Chance's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Sean Gathright. Number 1, Sean Gathright has no significant history of prior criminal activity. Number 2, Sean Gathwright's age at the time of the offense. 3, Sean Gathright was 18 years old at the time of the offense. 4, Sean Gathright was raised in a military family with repeated parental deployments, resulting in frequent relocations and prolonged separations from both of his parents. 5, Sean Gathright was primarily raised by his paternal grandmother due to parental absence and instability throughout his life. 6, Sean Gathright lacked a stable male role model or consistent guidance during formative years while he was a teenager. 7, Sean Gathright was subjected to verbal abuse by his father. 8, Sean Gathright was subjected to physical abuse and injury at the hands of his biological father. 9, Sean Gathright lived in an environment marked by fear, conflict, and lack of safety in his father's home. 10, Sean Gathright struggled with identity formation and belonging in adolescence. 11, Sean Gathright experienced isolation and difficulty adjusting socially after relocation in adolescence. 12, Sean Gathright was highly susceptible to influence due to his age. 13, Sean Gathwright's decision-making was influenced by peer groups and an unfamiliar culture. 14, Sean Gathright is described as kind, respectful, and nonviolent by family and friends who know him. 15, Sean Gathright is optimistic and a positive support for family and friends. 16, Sean Gathright loves his sister, nephews, mother, grandmothers, and friends. 17, Sean Gathright is loved deeply by the family who have supported him. 18, Sean Gathright has been described as calm, well-mannered, and non-confrontational. 19, Sean Gathright has the capacity to contribute positively to those around him. 20, Sean Gathright is a son, brother, grandson, and friend whose life has meaning to others. 21, Sean Gathright is capable of growth, redemption, and maturity because of his young age. 22, Sean Gathright has the desire and potential to mentor and positively influence others, particularly younger individuals in prison. 23, Sean Gathright fed the homeless and was very involved in community projects in Mississippi when he lived with his paternal grandmother. 24, Sean Gathright traveled to foreign countries on mission trips for humanitarian purposes. 25, Sean Gathright participated in educational international travel programs reflecting exposure to broader opportunities. 26, Sean Gathright demonstrated entrepreneurial initiative, including running small businesses, pressure washing, detailing, and photography. 27, Sean Gathright showed motivation and productivity at a young age. 28, Sean Gathright has demonstrated the desire to be productive by taking courses in an incarcerative setting. 29, Sean Gathright engaged in creative and constructive outlets, including photography and media work. 30, Sean Gathright has shown resilience and adaptability despite adversity. 31, Sean Gathright can contribute significantly to the prison workforce. 32, the existence of any other factors in SeanGathright's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Rashad Murphy. Number 1, Rashad Murphy has no significant history of prior criminal activity. Number 2, Rashad Murphy's age at the time of the offense. 3, Rashad Murphy was only 30 years old when the homicide occurred. 4, Rashad Murphy has a history of physical and emotional abuse as a child, consistent with childhood post-traumatic stress disorder. 5, Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. 6, Rashad Murphy has developed religious and spiritual awareness while incarcerated. 7, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide financial support. 8, Rashad Murphy loves his children and has been a good father to them. 9, Rashad Murphy, as a minor, was removed from his primary home and placed into foster care due to negligent and abuse situations in the primary home. 10, Rashad Murphy has no prior felony convictions. 11, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. 12, the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Mitigating circumstances as to defendant Davion Murphy. 1, the capacity of Davion Murphy to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. 2, the capital felony was committed while Davion Murphy was under the influence of extreme mental or emotional disturbance. 3, the age of Davion Murphy at the time of the offense. 4, Davion Murphy suffers from traumatic brain injury. 5, Davion Murphy was exposed to repeated violence in his childhood and young adult life. 6, Davion Murphy is in the borderline range of intellectual disability. 7, Davion Murphy grew up in a household marked by instability and financial strain. 8, Davion Murphy did not have a stable male role model in his life. 9, Davion Murphy's father was diagnosed with schizophrenia. 10, Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. 11, Davion Murphy took on a parental role for his younger siblings. 12, Davion Murphy is loved by his family. 13, the existence of any other factors in Davion Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. The final step in the process is for the jury to determine whether a defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist, and 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the result of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that a defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty for a defendant, the court must sentence that defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty for a defendant, your recommendation for that defendant must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided forms to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that human life is at stake, and bring your best judgment to bear in reaching your decisions. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? And 9, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Defendant Sean Gathright has become a witness in this case. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for the lawyers to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to the lawyers about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its aggravating factors against the defendants. It is not necessary for a defendant to disprove the aggravating factors. It is up to the state to prove the aggravating factors by evidence. Defendants Isaiah Chance, Rashad Murphy, and Davion Murphy each exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of any kind or be influenced in any way by this decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Criminal gang member applies only to defendants Isaiah Chance, Rashad Murphy, and Davion Murphy. Criminal gang means a formal or informal ongoing organization, association, or group that has as one of its primary activities the commission of criminal or delinquent acts, and that consists of 3 or more persons who have a common name or common identifying signs, colors, or symbols, including but not limited to terrorist organizations and hate groups. Criminal gang member is a person who meets 2 or more of the following criteria. 1, admits to criminal gang membership. 2, is identified as a criminal gang member by a parent or guardian. 3, is identified as a criminal gang member by a documented, reliable informant. 4, adopts the style of dress of a criminal gang. 5, adopts the use of a hand sign identified as used by a criminal gang. 6, has a tattoo identified as used by a criminal gang. 7, associates with one or more known criminal gang members. 8, is identified as a criminal gang member by an informant of previously untested reliability, and such identification is corroborated by independent information. 9, is identified as a criminal gang member by physical evidence. 10, has been observed in the company of one or more known criminal gang members 4 or more times. Observation in a custodial setting requires a willful association. It is the intent of the legislature to allow this criterion to be used to identify gang members who recruit and organize in jails, prisons, and other detention settings. 11, has authorized any communication indicating responsibility for the commission of any crime by the criminal gang. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 4, your duty is to determine whether the appropriate sentence in this case is life in prison without the possibility of parole or death. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. The verdicts must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Defendant Isaiah Chance, jury verdict form, penalty phase. We, the jury, find as follows as to Isaiah Chance in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. And you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should state and sign at the end of this form. If you, the jury, answered yes as to any aggravating factor listed, proceed to Section B. Section B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. Check only 1. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole. We, the jury, find Isaiah Chance should be sentenced to life in prison without the possibility. Oh, okay. let me back up. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. And then you would check one of the following two. We, the jury, find Isaiah Chance should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank, and you would fill that in, that Isaiah Chance should be sentenced to death. Dated this blank day of May 2026 in Hillsborough County, Florida, and there's a line for the foreperson of the jury to sign and print their name. As to defendant Sean Gathright, jury verdict form, penalty phase. We, the jury, find as follows as to Sean Gathright in this case. 8 aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And then the definitions I've already read to you regarding cold, calculated, premeditated, and a pretense of moral or legal justification. Again, you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. And again, you would check yes or no. Number 3, we, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. Again, check only one. We, the jury, have unanimously found the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. And again, you check one of the two. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Sean Gathright should be sentenced to death. Defendant Rashad Murphy, verdict form, penalty phase. We, the jury, find as follows as to Rashad Murphy in this case. Aggravating factors. Number 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the definitions are included there, and they are as I have instructed you previously. And you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons. Again, check yes or no. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. 4, we, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. And again, you would check only one. We, the jury, have unanimously found the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. Again, you check one. Either we, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Rashad Murphy should be sentenced to death. Okay, this blank day of May 26 in Hillsborough County, Florida. Again, lines for the foreperson to sign and print their name. Defendant Davion Murphy, verdict form penalty phase. We, the jury, find as follows as to Davion Murphy in this case. A, aggravating factors. 1, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And again, the same definitions apply as I previously instructed you, and you would check yes or no. 2, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Again, check yes or no. Number 3, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Again, check yes or no. 4, we, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Again, check yes or no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations. The foreperson should date and sign at the end of this form. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. And you'll only check one. We, the jury, have unanimously found that the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. And again, you check one of these. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole, or we, the jury, find by a vote of blank to blank that Davion Murphy should be sentenced to death. Dated this blank day of May 26 in Hillsborough County, Florida. Again, the signature and lines for the foreperson to sign and print their name. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson, and you keep the same foreperson if you decide, who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when your deliberations are concluded and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Okay, so does anyone have any electronic devices in the, okay, so you guys kind of know the drill. Juror 168, Mr. MN, do you have anything in the jury room that you need to get out? Okay, so this is the same as last time, right? So you guys we're going to go into the jury room. Do not begin discussing anything about this case until our alternate has left and until the bailiffs have left. You will receive all of the evidence that was submitted, and you will also receive, the bailiffs will bring in the actual final verdict form. Each of you, again, we're given a copy for your own use, but the official verdict form will be the stapled copies that the bailiff brings in, and that's what you all are to utilize. Okay, very good. So I'll talk to our alternate after you grab your items. If you have any electronic devices on you now, anything, leave them in your chair. Otherwise, the bailiff will collect them and bring them out here.
All right.
Okay. I just want to thank the attorneys for the state, Mr. Harmon, Ms. Ismer, Ms. Doherty, Mr. Hernandez, Mr. Gonzalez, Ms. Finkelstein, Mr. Sonardes, the various Sonardes, Mr. Petrides, Mr. Bolt. You all are just the height of professionalism and ethics, and it really is a pleasure to have you in my courtroom. I never, ever have to worry that any of you are going to violate the rules or treat each other disrespectfully or treat me disrespectfully, and it really just makes my job simpler. So I do appreciate it. So I just want to commend you all for that. Thank you. Okay, so I don't even really have the words to thank you for your service. It's such a hard thing in these cases, particularly cases of this magnitude that take this long. And we have alternates and you have to sit and listen to all the evidence. And then we tell you, surprise, you don't actually get to partake in the decision. But I do hope you realize how critically fundamental you are to the process. As we discussed before, in these cases, we have to have 12 people decide these verdicts. And if something happened and we didn't have an alternate, we'd have to start all over. And you now very well are very familiar with all that goes into these cases. So I just want to thank you on behalf of everyone, on behalf of the citizens of Hillsborough County. Thank you so much for your service. And the good news is you are now released from your jury service. You're free to talk to whoever you would like to about the case. You're free to stick around. You're free to go. And again, just thank you so very much. Thank you. Okay, so we'll be in recess pending a verdict.
Based on Mr. Gathwright's age, physical abilities, things like that, do you think that the prison would benefit from him in a work capacity if he were sentenced to life without parole?
I say yes. With my experience, not only just in classification, but as former ward and even as a jail administrator, he's someone that's young, he's healthy. In reality, we need that labor, we need that sweat equity, and we will put him out there to work because we do have an aging prison population, jail administration. We have that. So we put these young individuals to work and get some sweat equity out of them since they are young and actually can do the work.
And I know we talk about life without parole and death row, but for our jurors' education in Florida, what does a life sentence without parole mean?
A life sentence in the Florida Department of Corrections means from the minute they're brought in, they're assigned an inmate number. He will be assigned an inmate number, and when he dies and leaves in a body bag, he will still have that inmate number. An inmate serving life will never, ever get out. There is no parole in the state of Florida, and they're not ever allowed outside the razor wire and the fence of a secured facility.
So the only way that an inmate serving life without parole would leave is when they die by natural causes.
Ready, Judge?
Yes.
All rise.
All right, welcome back, members of the jury. We're ready to proceed. State, do you have an announcement?
Yes, Your Honor. At this time, the state would rest.
All right, and defense, do you renew all previously made motions?
Yes, Judge.
Okay, very good. Does the defense wish to call a witness at this time?
This time the defense calls Robert Howard to present.
Your Honor, very briefly, if we may approach.
Yes. Give the switch.
You've been there for maybe an event?
Yes, sir.
All right. And what events have you been to Rains High School for?
Basketball games, football games.
All right. Do you know what years?
Several years. 2018, 17, 16, etc.
Do you or are you familiar with Alicia Andrews?
Yes, sir.
All right. You know her from this case or you know her from before?
A little before.
You were familiar with Alicia Andrews because you'd seen her around?
Yes, sir.
All right. But you didn't have any personal relationship with her?
No, sir.
How did you see Alicia Andrews around?
Social media.
So you saw her page on social media?
Yes, sir.
Do you remember if you followed her?
I don't remember.
All right. And when you say you saw Alicia Andrews on social media, was this in like the 2018, 2019 time period?
Yes, sir.
All right. Well, let me go back. Have you heard of something called 6 Block?
Yes, sir.
In your view, is 6 Block a gang?
No, sir.
What is 6 Block?
Apartment complex.
And so it's not a neighborhood necessarily?
No, just apartment.
And where is that at? What side of town is that at in Jacksonville?
North side.
So did you grow up in that apartment complex?
No, sir.
Are you affiliated with 6 Block in any way?
Yes, sir.
All right. Tell me about your affiliations with 6 Block. What do you mean when you say you're affiliated?
Well, those apartments are in my neighborhood, so we're friends. I'm friends with people that's from those apartments.
Okay. So you live in a neighborhood around the 6 Block apartment complex?
Yes, sir.
And the neighborhood that you lived in, what was that called?
Avenue B. Okay. Avenue B.
Okay. Did you grow up with Charles Jones?
Yes, sir.
How long did you know Charles Jones for?
Almost all my life.
Do you know how old?
Like 8 or 9.
All right. Did Charles Jones live at the apartment complex called 6 Block?
I'm not sure.
Did he live in your neighborhood on the north side?
I'm not sure. Can't say.
Did you all go to school together?
No, sir.
Okay. But you knew him.
Yes, sir.
Were you two best friends?
We're really, really close. Almost like my best friend, you can say.
Okay. Did you have a best friend?
Yes, sir.
Who was your best friend?
Adrian Daner.
Is he affiliated with 6 Block in any way?
Yes, sir.
And what's his name? If he has another name.
Bibi.
All right. And you said you would not call 6 Block a gang. What would you refer to it as?
Apartments.
Do you refer to, okay, when individuals refer to 6 Block as a group, do you identify 6 Block as a group of individuals?
I don't, but the world do.
Okay. And why do you not identify it as a group of individuals?
Because I know it's an apartment complex. It's a nickname given by Charles.
Okay. These gangs in Jacksonville, there are gangs in Jacksonville?
Probably so, but not to my knowledge. I can't call out gangs.
Okay. Are there groups in Jacksonville?
Yes, sir.
People that are sort of affiliated with each other?
Yes, sir.
Is it like sort of based on where they grow up?
You can say.
All right. Is there a better way to describe it?
Basically, kind of what you said, based off of where you grew up at, what side of town.
Okay. And being either a part of 6 Block or affiliated with it, does that mean that you are necessarily involved in criminal activity?
No, sir.
Do you have law-abiding citizens affiliated with 6 Block?
Yes, sir.
You know of an individual named Gino Norris?
Yes, sir.
He was with you on the night of Charles Jones's murder?
Yes, sir.
And Gino Norris, is he affiliated with 6 Block?
Yes, sir.
All right. Is he related to Charles? Was he related to Charles Jones?
Not that I know of.
Were he and Charles Jones close friends?
Yes, sir.
All right. And Gino Norris was shot on the night that Charles Jones passed away?
I think so.
Is Gino Norris a gangster?
No, sir.
Is anything close to a gangster?
No, sir.
And why do you say that?
He's a human being.
Fair answer. But is Gino Norris involved in any of the rap music back and forth?
No, sir.
Is Gino Norris known to have committed any criminal acts?
No, sir.
You, in 2018, you were arrested. Is that accurate?
Correct.
All right. And the arrest from 2018 was for what?
Manslaughter.
That event, I'm not saying you did or didn't do anything. That event occurred where?
Rains High School.
All right. Was that during a football game?
Correct.
Was there another individual that was accused of the same manslaughter?
No, sir.
Was Bibi accused or involved in any way?
Oh, yeah, they was accusing us both. Yes, sir.
So there were accusations that both you and Bibi had shot and killed someone?
Yes, sir.
All right. The person that died in 2018 at Rains High School, what was their name?
Gerard Adams.
Did he have any sort of nicknames?
Yes, sir.
What was his nickname?
Spaz.
All right. Did you know Spaz personally?
No, sir.
Do you know if Spaz was involved in any gangs?
No, sir. Not to my prior knowledge. No, sir.
Do you know if he's in any groups?
Yes, sir.
What group is he in?
After a while, I seen that he was hanging with guys from 1200, like east side of Jacksonville.
All right. Ultimately, you ended up going to prison for that?
Yes, sir.
You were released at some point?
Yes, sir.
You know what year you were released?
2023.
Do you know what month you were released?
May.
All right. Were you released like out to go back home or any sort of halfway house or anything like that?
Objection relevance, Your Honor.
Overruled, go ahead.
Can you repeat your question?
Yeah. Were you released straight to go straight home?
Yes, sir.
All right. When you were released, did you and Charles Jones connect?
Yes, sir.
All right. And were you two hanging out maybe like you had done in the past?
Yes, sir.
Are you aware of who Davion and Rashad Murphy are?
Yes, sir.
All right. Are you aware of whether Davion and Rashad Murphy knew Spaz Gerard Adams?
Yes, sir.
All right. Are you aware that Davion and Rashad Murphy were related to Spaz Gerard Adams?
Yes, sir.
And did you ever have any idea that Davion Murphy or Rashad Murphy were either angry at you or trying to seek revenge for what they believe you may have done to Spaz?
I heard rumors.
All right. Because you're in 6th block, does that mean you hate other neighborhoods?
No, sir.
Does that mean you hate other groups?
No, sir.
Does that mean you hate, whether somebody calls it a gang or doesn't, does that mean you hate gangs that are in Jacksonville?
No, sir.
All right. Are the lines between these different groups or gangs, are they as clear as people make them seem?
Can you repeat it and explain more?
So 6th block and ATK are what they would call rivals
To the world, yes, sir.
to the world. Is there a chance that maybe some ATK affiliates or members might talk to 6th block affiliates or members?
Yes, sir.
All right. Is that against the culture or anything like that?
All human beings. Yes, sir. No, sir.
Do you all sometimes grow up together and end up in different groups?
Yes, sir.
Sometimes you went to school with individuals and were friends with them and they ended up in
Overruled, go ahead.
and they ended up in what the world would call a rival gang.
Can you repeat your question?
Right. So were you ever friends with people, let's say growing up, middle school, elementary, middle school, high school,
Yes, sir.
and they end up in a different gang or group of individuals?
Yes, sir.
Right. Does that mean that you automatically hate those people?
No, sir.
A lot of this back and forth, the rap music, was it put out to get views on YouTube or social media, the rap music?
Can you repeat your question?
Was a lot of the rap music, the drill rap music, was it put out to get views on YouTube and on social media?
Yes, sir.
Is all of it even true?
No, sir.
You know an individual named Isaiah Chance?
Yes, sir.
What is his I guess his name, his nickname?
Gutta Z.
All right. When did you come to know Gutta Z?
When I came home in 2023.
How did you meet or come to know Gutta Z?
Social media.
So you saw him on social media?
Yes, sir.
All right. And did one of you reach out to the other?
Yes, sir.
Who reached out to who?
I can't really recall. I think it was him, but I can't recall.
All right. Let me ask you this first. Did you and Isaiah Chance exchange phone numbers or ways to contact each other?
Yes, sir.
All right. And did you all contact each other at points in time?
Yes, sir.
Did you all used to talk on the phone?
Yes, sir.
Even on FaceTime as well?
Yes, sir.
And those conversations, sometimes they lasted hours.
Yes, sir.
And you all would just talk about random things.
Yes, sir.
Was it necessarily anything to do with the 6 block, ATK, 1200 gang stuff?
No, sir.
The phone number that Isaiah Chance would contact you on, do you know if that phone number belonged to him?
No, sir. I can't. No, sir.
Did you ever have any indication that the number belonged to Alicia Andrews?
Yes, sir.
And Isaiah Chance would contact you on that phone number, the same one every time?
No, sir.
Different number?
Yes, sir.
Okay. Your relationship with Isaiah Chance, would you call it cordial?
Cordial, yes, sir.
You and him ever get into any issues?
No, sir.
All right. At any point in time, did you ever have any communication with Alicia Andrews?
No, sir.
Did you ever reach out to Alicia Andrews for anything?
No, sir.
Have you ever seen her in person?
I think I recall a long time ago, early 2018, 17.
Okay. Do you know if that was at Reigns?
Most likely, yes, sir.
Okay. Like at a football game or basketball game or something like that?
Yes, sir.
All right. How do you remember her from so far back?
Seeing her around, she was kind of a little known. So,
All right. Because of the way she looks?
Yes, sir.
All right. And when I say that, what do you mean by that? Or when we both say that, what do you mean by that?
Objection, relevance? Bro, go ahead.
Well, she was a pretty girl, but that's about it. Just like that.
Did you have any friends that wanted to talk to Alicia Andrews?
Not that I remember, no, sir.
All right. I want to go to the trip that happened in June of 2024 from Jacksonville to Tampa. Did you go on a trip with Charles Jones from Jacksonville to Tampa?
Yes, sir.
All right. And this was in June of 2024?
Yes, sir.
During this trip that you went on with Charles Jones, who went with you?
Me, Charles, and Gino. Gino Norwood.
Okay. Just the three of you?
That was in the car, yes, sir.
All right. And you all drove down in the Charger?
Yes, sir.
The individuals, did you go to an Airbnb when you arrived in Tampa?
Yes, sir.
And were there other individuals that joined you all at the Airbnb?
Yes, sir.
All right. Where did those individuals come from?
Jacksonville as well.
All right. So how did they know to get to the Airbnb?
I think Julio gave them those guys the address, most likely.
At some point that weekend, was there a pool party?
Supposed to be one, yes, sir.
What do you mean supposed to be?
It was supposed to be a pool party, but a lot of people didn't show up, so I guess it was like a little small gathering, not an actual pool party.
Okay. You said not a lot of people showed up?
The first day we got there.
All right. And was it publicly broadcasted, this pool party?
The first day we got there, no, I don't think so.
All right. Was there a second pool party?
The same, it was people there the second day we had. we had an Airbnb, so you can say.
All right. And how did people know to come? Were people allowed to come if they just asked to be there?
I think Foolio reached out to people.
All right. Were you driving the Charger at any point in time?
Yes, sir.
When were you driving the Charger?
To Tampa.
So you drove from Jacksonville down to Tampa?
Yes, sir.
Did you go out to any clubs?
Yes, sir.
Did you go out to clubs on both nights that you were in Tampa?
Yes, sir.
All right. I want to talk about the Saturday night. Do you remember that night?
Yes, sir.
All right. Were you on a flyer?
Yes, sir.
And had you ever been on a flyer before for a party?
Yes, sir.
Okay. Have you ever gone out of town to Tampa before?
Yes, sir.
With Charles Jones?
Yes, sir.
For the same sort of thing or something different?
Same sorts of thing.
All right. You know a promoter or something in Tampa?
Yes, sir.
All right. So you are at the Airbnb at some point on Saturday. Do you leave to go to a club?
Yes, sir.
Which club do you go to?
I don't know. I don't recall the name of the club, but I went to a club.
All right. Do you recall the area that it was in?
No, sir. I don't know Tampa like that. No, sir.
Were you driving?
No, sir.
All right. Were you paying attention to where you were going?
Yes, sir.
Why?
I think as a young man or anybody, you should always pay attention to your surroundings.
Okay. Did you have any fears or caution about hanging out with Charles Jones?
No, sir.
All right. At any point in the night, did you ever get upset with him about posting his locations?
Yes, sir.
Why?
Because we're both two known individuals. You know, we got people that love us, people who hate us. So.
Okay. And I guess would you prefer that your locations be anonymous?
Yes, sir.
Why do people hate you all? Not to say that everyone does, but why are there people that have that feeling?
Jacksonville is built with drill rap. Foolio's a drill rapper. So.
All right. The club that you went to first, do you remember what it looked like?
Yes, sir.
All right. And you arrived at the club. Did you go inside?
Yes, sir.
And why did you leave?
So why did we leave?
Yeah. At some point, so let me back up. Did you leave the club at some point?
Yes, sir.
Why?
The show was over. It was closed. I think it was ending.
Okay. And where did you go after that?
Went to another club.
All right. Do you remember the name of that second club?
No, sir.
All right. You left the second club at some point in time. Is that accurate?
Yes, sir.
And why did you leave the second spot?
It was getting late. We were getting tired.
And where were you going after you left the second spot?
To find a hotel to crash.
After you, did you get to the hotel at some point?
Yes, sir.
All right. When you got to the hotel, who all was there?
Me, Charles Jones, Gino, Charles' girlfriend at the time, a friend of hers, several friends.
All right. When you got to the hotel, did something happen?
Yes, sir.
What happened at the hotel?
A shooting.
All right. Did you see any of the people who did the shooting?
No, sir.
All right. And did you later come to find out that two of the people arrested for the shooting were Davion Murphy and Rashad Murphy?
Yes, sir.
All right. Did either of them contact you after the murder?
Just one.
Which one?
Rashad Murphy.
Rashad Murphy contacted you how?
He texted me.
How did he have your number?
Had conversations.
You've spoken to him before?
Yes, sir.
Like friendly conversations?
Yes, sir.
When Rashad Murphy texts you, did it have anything to do with Foolio's death?
He said he forgives me. So
Forgives you for what?
that's what I was trying to figure out.
So you don't know.
She said he forgive me.
Did you respond?
I don't recall responding.
And was there ever any conversation between you and Rashad Murphy about Spaz in the past?
Yes, sir.
Were any of these conversations about whether you had done anything to Spaz?
Yes, sir.
And those conversations you're saying were friendly?
Yes, sir.
Does 6th block have a hand sign?
Yes, sir.
All right. That hand sign, or let me ask you this: is there a hand sign for 21st Street?
Yes, sir.
Is there one for 1200?
Yes, sir.
Are the signs for 1200 and 21st, are they the same?
I don't think so. No, sir.
And what about the signs for 6th block? Is it the same as 1200 and 21st?
No, sir.
The sign for 6th block, can you describe what it is?
It's like 3 fingers holding up. It's like a 6 almost. Like
So something like this?
yes, sir.
All right. And if an individual uses that hand sign, does that mean that they're part of 6th block?
No, sir.
Do sometimes people use those hand signs when they're not actually a part of 6th block?
Yes, sir.
I'm showing you what's in evidence as State's Exhibit 95C. 2. Is this the flyer from the party at Teasers?
Yes, sir.
All right. The hand signs that Charles Jones is using, are those 6th block hand signs?
No, sir.
What hand signs are those?
I don't even know. He is posing.
Did he pose like that often?
Yes, sir.
With those same hand signs?
Yes, sir.
All right. Does that mean 2100 or 21st?
No, sir.
Does it mean 1200?
It could be several meanings.
Okay. Would Charles Jones, coming from 6th block, would he ever be throwing up these hand signs for 1200 and 21st?
No, sir.
All right. So that to you does not mean 1200 or 21st.
No, sir.
All right. 1200 and 21st, those are east side. That's east side of Jacksonville.
Yes, sir.
And Charles Jones is not from the east side.
No, sir.
if you see an individual with those hand signs that you saw Mr. Jones with just now,
Yes, sir.
does that mean that they're gang affiliated?
No, sir.
All right, I don't have any other questions. Thank you.
Cross-examination.
Mr. Howard, do you have a nickname?
Yes, ma'am.
What is that?
Kenny Caps. Yes, ma'am.
Kenny? Why?
South Park.
Is it related to your stature? Someone from South Park, a small individual or smaller in stature individual?
Yes, ma'am.
Okay. And have you been known by that name before you were incarcerated?
Yes, ma'am.
Now, you said you were accused of the murder of Spaz or Joe Rod Adams that occurred at Rains High School in 2018. Is that right?
Yes, ma'am.
But the fact is, you were convicted of that homicide, correct? That's the manslaughter conviction.
Yes, ma'am.
Was there anyone else with Spaz at Rains High School when Spaz was shot?
Yes, ma'am.
Who was that?
Willie Roy.
Willie Royal.
Yes, ma'am.
And Willie Royal is Will Go Crazy on Instagram and known to people. That's his tag.
Yes, ma'am.
Will Go Crazy.
Yes, ma'am.
And Willie Royal survived that shooting. Isn't that right?
Yes, ma'am.
Now, you were asked several times about your communications with Isaiah Chance and Rashad Murphy, and you said that they were friendly.
Yes, ma'am.
So you are testifying that you would be friendly with them on the outside, so not on the telephone. You would go out with them to a club and that be posted everywhere?
No, ma'am.
When you say friendly, why don't you explain to me what you actually mean by that?
Just conversation. We're not yelling. We're not arguing. We're just talking.
What's the goal of you having a long, hours-long conversation with Isaiah Chance?
Trying to see how to word it. Let's see what you know. See the learn his thoughts.
Your intent on talking to Isaiah Chance or anybody that is an up or from the opposite side of your group, whatever group you want to call it, gang, not gang, whatever you want to call it. Your goal is to catch them slipping, to catch them doing something wrong.
Yes, ma'am.
You want to know more information about your ops than they know about you.
Yes, ma'am.
Is Isaiah Chance calling you from different numbers all the time a part of what you would employ yourself?
Yes, ma'am.
Why would you call from your own number every single time you talk to him? Would that be smart?
No, ma'am.
Okay. So one time you believe that your girlfriend checked the number or a number you spoke to and it said Alicia on the phone.
Yes, ma'am.
So I assume you got in trouble with your girlfriend for that.
Yeah, my ex. Yes, ma'am.
And you've seen Alicia Andrews around. I want you to tell me what the context was that you actually saw her around before you went to prison.
Yes, ma'am.
How? Was she dating someone that you knew at the time?
I didn't have any knowledge of that. So, but
Is the person in States 90B the person that you identify as Alicia Andrews?
yes, ma'am.
Did you know her by another name around town?
No, ma'am.
Okay. Did you know even her legal name when this event actually happened, before it started being reported to the news?
No, ma'am.
You said you would talk to somebody named Rashad Murphy. That's the individual depicted in 37A, isn't it?
Yes, ma'am.
And had you seen him on social media as well?
Like a blur, not. Yeah, I didn't see his Instagram, but not him posting himself on Instagram.
Okay. Well, his Instagram account name was Ghost187, right?
Yes, ma'am.
Was it rare to get a glimpse of Rashad Murphy's actual whole face?
Yes, ma'am.
When you talked to Rashad Murphy on the phone, like you've testified, and FaceTime with Rashad Murphy, did he show you his face and his surroundings and the people that he was hanging out with on a FaceTime?
No, ma'am.
So what could you see?
Like the ceiling.
He wouldn't show you his face?
No, ma'am.
Did you ever actually see his face to be able to confirm that that was Rashad Murphy, that was the person talking to you on the phone?
One time.
So you did see his face at least once.
Yes, ma'am.
Is that what you're talking about when you catch people slipping? You catch them in a weak moment?
Yes, ma'am.
The longer you talk on the phone with Rashad Murphy or Isaiah Chance, does that increase or up your chances of getting some information about them?
Yes, ma'am.
Honestly speaking, the fact that your girlfriend reverse searched and found out that it was Alicia Andrews' phone number that called you once from all of the calls that you got from random numbers from Isaiah Chance got caught.
Yes, ma'am.
You didn't know what Alicia Andrews' phone number was before that.
No, ma'am.
That is a part of the lifestyle, right?
Yes, ma'am.
So currently, right now, you're incarcerated.
Yes, ma'am.
You're here presented in orange, right?
Yes, ma'am.
And you certainly have at least some knowledge of the Jacksonville gang scene.
Yes, ma'am.
Will you ever testify that 6 Block is a gang?
No, ma'am.
You understand the statute? What's required, what law enforcement says defines a gang?
No, ma'am.
Do you think it's against your interest for some reason to admit that 6 Block is a gang?
Can you rephrase it in a different way?
You certainly know that you admitting that 6 Block is a gang and you're associated to them is one of the elements of the gang statute. You're never going to admit that you're a member of 6 Block.
No, ma'am.
You're never going to admit that anybody is a member of any gang.
No, ma'am.
You're never going to call any of these groups a gang.
No, ma'am.
Okay. You were asked specifically about whether you had prior conversations or interactions with a Davion Murphy. Is that what we're seeing in 38A?
Yes, ma'am.
You understand him to also be a co-defendant in this case.
Yes, ma'am.
And what was the interaction that you had with Davion Murphy?
We had words in Duval County.
Okay, what were the words?
He told me that Gerard Adams was his cousin. And I was like, so? And he was like, he gonna get up with me. And I was like, okay.
Did you think that that was a polite reference, that he was going to get up with you?
No, ma'am.
Did you know this man?
No, ma'am.
At the time that he told you Gerard Adams was his cousin and he was going to get up with you, what were you incarcerated for?
I was accused of the murder of his relative.
His relative being Joe Rod Adams.
Yes, ma'am.
35A, is this the person that you talked to on the phone, identified as Isaiah Chance?
Yes, ma'am.
I'm going to show you what's been previously marked for identification as 75B7 from an extraction from this defendant's cellular device. Can you identify any of the individuals depicted in 75B7?
Yes, ma'am.
Who's the individual on the left of this image?
Gerard.
That's the individual that you were convicted of killing.
Yes, ma'am.
And the individual that Davion Murphy was referencing when he said he was going to get up with you.
Yes, ma'am.
Can you identify the individual on the right?
Corbin.
Corbin?
Yes, ma'am.
Is that Corbin Johnson?
Yes, ma'am.
Is that the individual that we've been hearing about went missing in some way or was kidnapped in some way?
Yes, ma'am.
You are familiar with Julio Foolio's social media activity.
Yes, ma'am.
And when you say you're from, where did you say you're from?
45th.
45th. Do you claim any kind of neighborhood openly, like in public, other than 45th or 6 Block?
Yes, ma'am.
Is that Ave B?
Yes, ma'am.
And what is that? Can you tell the jury what that is?
45th Avenue B is a section on 45th. It's
So
a part of 45th.
I'm sorry, I didn't cut you off. It's a part of 45th?
Yes, ma'am.
Same area.
Yes, ma'am.
Before you went to prison, was it typically people from separate areas would be affiliated with separate groups?
Yes, ma'am.
And how old were you when you got arrested for Gerard Adams' homicide?
16.
16.
Yes, ma'am.
What was the total sentence that you ended up serving?
4 years, 10 months, 4 years, 11 months, one of them.
When you were released from custody for that case, is that when Rashad Murphy made contact with you?
Yes, ma'am.
What was the nature of that contact? Because you've indicated it was friendly.
Just basically trying to see who was the gunman of his family members relative.
He wanted to see who the gunman was? Is that what you said?
Yes, ma'am.
Was there some question about whether you were the person who actually pulled the trigger that killed Spaz, aka Joe Rod Adams?
Yes, ma'am.
You have indicated that you understand or have at least seen some of the back and forth with these drill rap videos.
Yes, ma'am.
Why is Kenny Caps never disrespected in those videos?
I'm highly respected.
Why?
Because I believe, I'm a stand-up guy, and I didn't give up. I didn't give up my friend, or I didn't say any names when I got arrested for the manslaughter of the Gerard Adams.
Okay, so let me make sure that I understand this correctly.
Yes, ma'am.
At the homicide of Joe Rod Adams, there were other individuals present,
Yes, ma'am.
and you didn't give up any names.
Correct.
Was Bibby present at the homicide of Joe Rod Adams?
Yes, ma'am.
And what's Bibby's real name?
Adrian.
Adrian
Yes, ma'am.
Gaynor?
Yes, ma'am.
And did Adrian survive much longer after Joe Rod Adams died?
No, ma'am.
When you went to jail for that, was it pretty quickly after Spaz was killed at the high school?
Yes, ma'am.
And did Bibby pass away while you were incarcerated for that murder?
Yes, ma'am.
During your entire time incarcerated, did you ever give a statement about Bibby or anyone else associated with that murder?
No, ma'am.
So when you tell us that you're highly respected, it's because you didn't tell on anyone.
Yes, ma'am.
When you say that, or when I'm asking you about whether your name is in any of these music videos, why aren't ATK 1,200 members or even other people that might not like you dissing you?
For those reasons, highly, a lot of respect in Jacksonville.
Are you talking on anybody else's deceased family members?
No, ma'am.
When you went to prison, what year did you actually go?
2022.
When you were arrested, was that still in 2018?
Yes, ma'am.
At the time that you were arrested in 2018, was it common to commit a crime for your friends or members of your ops and then admit to all of the details of the crime in a music video?
No, ma'am.
When you came out of prison, was that something that you frequently saw?
Yes, ma'am.
And did you engage in that, or did you start to engage in that?
I never engaged in it.
So is that why Rashad Murphy is then contacting you and asking what happened with his cousin? You were already convicted and had done a prison sentence. I don't understand why he's contacting you after. You said
ma'am.
you did it.
Yes, ma'am.
Why? Why is he contacting you?
Because it was a lot of rumors that I didn't have anything to do with it.
But
So-
you didn't snitch.
But I didn't snitch. Yes, ma'am.
Was Rashad Murphy, or did Rashad Murphy ask you to tell him who actually did pull the trigger?
Yes, ma'am.
Did you see, or were you familiar with any drill raps from 6 Block members naming Joe Rod Adams or Spaz and dissing him?
Yes, ma'am.
Was that brought up by Rashad Murphy?
Yes, ma'am.
Rashad Murphy and Davion Murphy were contacting you because they wanted to find out who killed their cousin.
Not Davion.
So he only talked to you that one time in the jail,
Yes, ma'am.
and Rashad would contact you.
Yes, ma'am.
You said the communications were friendly, so he never threatened you.
No, ma'am.
He didn't threaten your family.
It was rumors he threatened my family. Yes, ma'am.
How long before Charles Jones was murdered in Tampa did he do that?
That year I was home within that span of that year before I got incarcerated.
You were asked about a hand sign that Charles Jones was doing in States 95C2. Is that right?
Yes, ma'am.
Who is 21st Street affiliated with?
IDs.
Okay, so 1200.
Yes, ma'am.
Let me ask it this way, because you don't want to say it's a gang. If 1200 and 21st Street were in the same room, would anybody be pulling out firearms or fighting
Yes, ma'am.
with each other?
Oh, no. I can't really. I don't know.
Okay.
Yes, ma'am.
How about this? Those two are affiliated or at least aligned enough that a common enemy of both is 6 Block or their members.
I'll say 21st. I mean, I'll say 1200. Not really 21st.
Who does 21st have problems with?
I think 1200.
You think?
Yes, ma'am.
Do you know?
No, ma'am.
Can you even tell me whether Charles Jones is putting this sign up to be disrespectful or whether he's claiming 21st?
Yeah, he's not. He's just throwing up a sign. He's not being disrespectful.
Realistically, you all or you at least personally have knowledge that there are members of 6 Block, there are members of 1200, there are members of ATK that throw the rival gangs signs and post it on social media.
Yes, ma'am.
That's true. It's a fact, right?
Yes, ma'am.
That happens.
Yes, ma'am.
I'm showing you from the cell phone extraction of the defendant in this case, what's been admitted as 76B5. Are you familiar with Charles Jones or Julio Foolio's social media posts?
Yes, ma'am.
Do you remember a social media post? I'll show it to you a little bit clearer. 95C3 that Charles Jones made about the attempted murder on his life, dated February 8th of 2024.
Yes, ma'am.
And was this a reel, meaning it was like a video that was posted to social media?
Yes, ma'am.
And is he referring to the attempted murder that happened on his life on October 7th of 2023, where he was shot in the foot?
Yes, ma'am.
Do you recall any other time where he was shot in the foot?
No, ma'am.
From that same post, Charles Jones is making this hand gesture. Is this what you were referring to when you said that 6 Block may throw a 6?
Yes, ma'am.
You are from AVB. Does that mean you wouldn't throw a 6 with your hands?
Yes, ma'am.
You would not ever throw a 6?
No, ma'am, I would. Yes,
Oh,
ma'am.
okay.
Yes, ma'am.
Is 6 Block is an area. I understand the concept that 6 Block may be a neighborhood, but it is also a moniker that Charles Jones uses when he posts rap videos. Is that correct?
Correct.
And it is a moniker that other individuals that may not say I'm 6 Block or be from 6 Block, like yourself from AVB,
Yes,
will also throw on for social media, music videos, etc. Isn't that right?
yes, ma'am.
Would you ever be in a position, particularly after your conversations with Rashad Murphy and Isaiah Chance, where you would hang out in public or go out with people in public that are throwing signs from the opposite groups?
No, ma'am.
Did you have any indication from Isaiah Chance that the night that you came down or the next night or the weekend, you were in danger?
Yes, ma'am.
Isaiah Chance, is he an individual who you know from childhood that you grew up with?
No, ma'am.
Have you seen the videos or photos from his arrest?
Yes, ma'am.
You remember that video? It looks really cool. The background, the houses,
Yes,
there's like a
ma'am.
big truck there. You remember that?
Yes, ma'am.
You saw that video of him being arrested.
Yes,
It's
ma'am.
raining.
Yes, ma'am.
We're on the same page. You know exactly what I'm talking about.
Yes, ma'am.
Did you grow up in a golf course, gorgeous community like that?
No, ma'am.
Do you know him or Sean Gathright?
No, ma'am.
You didn't grow up for years and years and years, like with them.
No, ma'am.
Is 6 Block a beautiful stretch of area that looks just like those gated communities in that golf course?
No, ma'am.
Is AVB beautiful and gorgeous like that?
No, ma'am.
Melvin Park?
No, ma'am.
So Isaiah Chance comes onto the scene and you know him from social media.
Yes, ma'am.
You had not seen him before that.
Never.
Was he a big rap name before that?
No, ma'am.
Is it unusual, at least from the time that you have grown up in Jacksonville, for people to switch sides completely? So that would mean somebody from, for example, 6 Block switching completely to ATK.
No, ma'am.
Does that happen?
No, ma'am.
How about between groups, right? There's nothing that says there's no problems that happen between the two groups, 3 groups, whatever it is, right? You could have members of ATK that fight with each other.
Yes, ma'am.
Can't you?
No, ma'am.
No one from ATK can fight with each other. I don't mean get into a shootout. I mean have a disagreement.
Yeah, friends have disagreement. People have disagreements. So that's
Right.
Yes, ma'am.
and they switch to other subsets. They may not stay with one group.
No, that's not really common, but it'll happen.
That's not common,
No, ma'am.
but it does happen.
Yes, ma'am.
Then how is Isaiah Chance, NHG, ATK, and now 1,200 within 24 months?
He's not really from anywhere. He's not really from a neighborhood.
Yeah, so you don't actually see him before you go to prison or as y'all are growing up, maybe playing football together or something
No, ma'am.
with other 1,200 members,
No, ma'am.
with other NHG members,
No, ma'am.
other ATK people.
No, ma'am.
Everybody else have known each other since children.
Yes, ma'am.
Are Isaiah Chance and Sean Gathright some of the only local people that you are aware of that live in the nice side of town?
Yes, ma'am.
You don't have, Charles Jones didn't grow up in a big mansion.
No, ma'am.
Fair to say he's probably one of the more successful of your group.
Yes, ma'am.
Okay. But no one grew up in those areas.
No, ma'am.
Can you explain how it's possible for Isaiah Chance to be switching from group to group to group like this? Why would one group even accept him if he left one subset to go to the next?
To use them, probably.
Well, did you actually see on social media Isaiah Chance denouncing NHG and ATK?
Yes, ma'am.
Why? Why was he doing that?
Yeah, I think he fell out with members of those groups.
Yeah, and then he started, you saw a social media post where he started posting and he tagged Ghost187, Rashad Murphy, his new 1,200 friend, right? You saw that.
Yes, ma'am.
So he again switched.
Yes, ma'am.
Is that something you have done?
Never.
Anybody in 6 Block that you're aware of switch up like that?
No.
Did Charles Jones and Gutazay or co-defendant Isaiah Chance get into it on social media?
Yes, ma'am.
Was that pretty out there on social media?
Yes, ma'am.
Did you see them on Spaces getting into it?
Yes, ma'am.
Do you recall what they were getting into it for?
Yes, ma'am.
What was that?
Gotta say fake clothes.
Fake clothes.
Yes, ma'am.
He was posting wearing designer clothes, wasn't he?
Yes, ma'am.
And Charles Jones was making fun of him on social media, wasn't he?
Yes, ma'am.
Charles Jones has lots and lots of followers on social media, doesn't he?
Yes, ma'am.
Including the defendant in this case, Elisa Andrews. Did you know that?
No, ma'am.
You didn't know she follows him?
No, ma'am.
Would Charles Jones get into it with Ace on social media? Foolio and Ace get into it?
Not though. I remember. I recall.
Well, maybe not on social media, but YouTube videos.
Yes, ma'am.
You know, interviews with podcasters or music videos, drill raps that they're posting. They don't like each other.
No, ma'am.
It's pretty clear from the music videos.
Yes, ma'am.
And you admit Charles Jones really, really gets into it with people. I mean, he goes deep.
He does.
Right before the homicide actually occurs, are you familiar with the post that Charles Jones made to his social media account blasting ATK and their CEO Ace?
No, ma'am. I wasn't aware of it.
You're not aware of the social media post that he made about a thigh bone?
It's been a minute. I probably seen it.
Would it refresh your recollection to look at that post?
Yes, ma'am.
Your Honor, may I approach?
Yes.
Okay. I remember it.
You remember the post?
Yes, ma'am.
On June 11th, which we've heard testimony about that Spaces incident between Gutazay and Charles Jones and how does his foot feel. We heard testimony about that happening on June 6th.
Yes, ma'am.
So on June 11th, is there a post from Charles Jones laughing about how Ace dropped y'all ass from the label and Corbin getting kidnapped?
What's your question?
Is there a post about that?
Yes, ma'am.
Okay, that's not uncommon for Charles Jones. Let's be honest. It's not uncommon for him to post something that's going to make somebody else upset, is it?
No, ma'am.
No. He does that all the time.
Yes, ma'am.
Does he get revenue or clicks from doing things like that?
Yes, ma'am.
Is he probably one of the most at least successful in social media in six block.
Yes, ma'am.
He's also referred to as 6.
Yes, ma'am.
You mentioned Gino Norris, and I want to talk specifically about Gino Norris. Have you ever been in a scenario where Gino Norris was involved and there was some kind of negative activity or behavior going on?
Not that I recall, no, ma'am.
Gino Norris has a real job, doesn't he?
Yes, ma'am.
Gino Norris is quiet and reserved and shy. You never usually actually go out with him, do you?
No, ma'am.
Was the trip down to Tampa with Gino actually one of the rare times he goes out with y'all?
Probably the first, yes, ma'am.
And he doesn't get involved in any of this back and forth.
No, ma'am.
Gino Norris is not in these music videos.
No, ma'am.
He's not throwing any gang signs.
No, ma'am. I can't recall.
You've never seen him throwing gang signs.
No, ma'am.
He doesn't do this.
No, ma'am.
Now, on the night of the actual homicide itself, Gino Norris was also there
Yes, ma'am.
with several other individuals in that little cover area
Yes, ma'am.
outside of the Holiday Inn, home to suites.
Yes, ma'am.
And you've subsequently become aware that Gino Norris was shot
Yes, ma'am.
as a result of his being inside of that car.
Yes, ma'am.
Do you have any personal knowledge of anybody having a problem with Gino Norris?
No, ma'am.
And you said Spaz, the individual, Joe Rod Adams, that was killed at the high school game, he was grouped to 1,200, right?
Yes, ma'am.
Just like co-defendants Rashad Murphy and Davion Murphy, right?
Yes, ma'am.
His relationship to Davion is his younger cousin, and his relationship to Rashad is his little brother. Isn't that right?
Yes, ma'am.
There weren't just rumors about you having not committed this crime or having committed this crime, whatever it was. They called you and and confronted you, especially Rashad Murphy.
Yes, ma'am.
Did you receive a warning of some kind from Isaiah Chance before you came down to Tampa?
Yes, ma'am.
Can you tell me what exactly that warning was?
It was probably like 3 or 4 days before we went. He was just saying, be on beat. I think it was his exact words, be on beat.
How did he relay that message to you?
The phone.
Be on beat?
Yes, ma'am.
What does that mean?
Like, be on alert.
Why would he tell you that?
I don't know. I guess he called himself being cordial. He just said, be on beat.
Did he say, be on beat when you go to Tampa this weekend with Charles Jones?
Yes, ma'am.
He specifically said it was this for the weekend?
No, he said he seen the flyer. They're like, be on beat down now. That was that.
Did you know or were you aware that Rashad Murphy liked the flyer that you were depicted in on the 14th on the day it was posted?
No, ma'am.
Had you been aware of that, would you still have come to Tampa?
Yes, ma'am.
You're not scared of Rashad Murphy having done anything or anything like that?
No, ma'am.
How about had you got to Teasers, pulled up outside and seen Rashad Murphy in the parking lot, would you have been concerned about that?
Yes, ma'am.
How about if you went to those locations and you saw Alicia Andrews and Isaiah Chance in the parking lot?
Yes, ma'am.
You would have been concerned.
Yes, ma'am.
You would have known it's not normal.
Yes, ma'am.
They would never be in that same location from you in Tampa
Yes, ma'am.
and coming inside to hang out with you and your other friends.
Yes, ma'am.
Would you have relayed that they were outside to Charles Jones and the rest of your group?
Yes, ma'am.
You knew Miss Andrews enough to know that she certainly wasn't affiliated with any members of 6 Block. Isn't that correct?
Yes, ma'am.
Now, back in 2017, 2018, you know somebody named Kay Shorty?
Yes, ma'am.
Is he affiliated to 6 Block?
Yes, ma'am.
Meaning he would get along with 6 Block.
Yes, ma'am.
And at that time, he would have been in high school, I guess. Is he a part of something called We All We Got?
Yes, ma'am.
To be fair, there's like, he's wearing sweaters with that on it, social media, like it's not a secret.
Yes, ma'am.
And at that time, did you know him to be in any kind of relationship with the defendant, Alicia Andrews?
No, ma'am.
Did you know anything even about her?
No, ma'am.
Did you know that her phone contained a video or in a chat of them together talking about 6 Block?
No, ma'am.
Did you know that they were talking about you?
No, ma'am.
Do you know the contents of her messages about you as K Shorty?
No, ma'am.
Have you talked at all with anybody about the content of those messages, including the defense?
No, ma'am.
Mr. Howard, Davion Murphy did not like you, did he?
No, ma'am.
And Rashad Murphy did not like you.
No, ma'am.
The only clubs that were posted via a flyer to social media were the clubs that you attended on the actual night and into the early morning hours of the homicide, right? So Truth 18 and Teasers, isn't that correct?
Yes, ma'am.
The places that you went when you all got there on the first night, which was Friday night, there was no kind of promotion for that or club flyer.
No, ma'am.
Did you help when Julio would go to these appearances and check out the location, make sure that he got paid, those types of things?
Yes, ma'am.
You didn't have any of that for Friday night.
No, ma'am.
The only ones that would have been publicized were Truth 18
Yes, ma'am.
and Teasers.
Yes, ma'am.
You indicated you had a friendly conversation with Rashad Murphy where he well, maybe it's not the same one. You had previous to Charles Jones's homicide, friendlier conversations with him. Are you still calling them friendly?
Yes, ma'am.
Why? Because you're not cussing each other out on the phone?
Yes, ma'am.
Him asking you about whether you killed his younger brother, I'm confused or kind of little, I guess maybe just confused about how that could be not anything.
Man-to-man conversations, not we're just talking normal.
Well, he wasn't happy with you, was he?
No, ma'am.
He wasn't asking if you wanted to go do things together, was he?
No, ma'am.
You said that Rashad Murphy contacted you after the homicide of Charles Jones. Is that right?
Yes, ma'am.
When?
I made it back to Jacksonville.
What did he say to you specifically?
He forgives me.
For what, Mr. Howard?
That's what I was trying to figure out. I don't recall me responding, but he just said he forgives me.
And you have no idea what he was talking about?
I guess he's saying for his brother.
So you're even?
Guess so. I think so. Yes, ma'am. Guess that's what he was indicating.
Not I think so. Didn't you see a social media post at like 5 a.m. or something right after the murder happens from Isaiah Chance or Rashad Murphy?
Yes, ma'am.
Didn't you believe at that time that was 1200 taking credit for killing Charles Jones?
Yes, ma'am.
Had you even contacted his mom at that point?
No, ma'am.
Had you even been interviewed by law enforcement at that point?
No, ma'am.
Had you talked to anyone but the people at the scene at that point that you can recall?
Yes, ma'am.
Okay. You were sending messages to whom?
My mom, my sister, family.
But you were still there.
Yes, ma'am.
You see it on media outlets at the time you saw them posting that?
Yes, ma'am.
You saw it already on the news?
No, ma'am.
Okay. So did you see the social media posts by either Isaiah Chance or Rashad Murphy before the news got a hold of the story that Julio Foolio had been murdered?
Yes, ma'am.
Your Honor, may I have one moment, please? Yes. Can you please remind me what it is that the affiliation between 21st and 6th Block would be? If any, same side or opposite sides, just down to that.
Different sides of town. Yes, ma'am.
Not geographically. Same sides if we go out and everybody's getting into a fight, or different sides, since you won't say gang.
Different side.
Different sides.
Yes, ma'am.
Why would Charles Jones be putting up 21st in posts or on social media? Is it the same reason he'd post himself in front of a picture of Melvin Park?
No, ma'am. That's 21st. We're not 20. We don't really have problems with 21st. At 20, I don't. 21st is not really someone we have problems with.
I'm trying to ascertain whether, so they're not even involved in this beef back and forth.
No, ma'am.
I'm trying to understand why Charles Jones would throw a 6 with his hand and then also throw up 2 and 1.
That handshake can go along with basketball players using it, other people using it. I think he was just throwing up a, because I got pictures like that, and I don't.
But there's a clear difference in throwing up a 6.
Yes, ma'am.
Or making a 6 with your hand and pointing it down towards the ground if you're the opposing side or the ops.
Yes, ma'am.
That is a sign of disrespect.
Yes, ma'am.
What about 1200? There's a clear delineation between a 1 and a 2.
Yes, ma'am.
That is, in fact, a hand sign utilized by 1200 members.
Yes, ma'am.
Your Honor, may I just have one more moment? Yes. Mr. Howard, thank you. I have no other questions.
Yes, ma'am.
Okay, redirect.
The night that Charles Jones was killed, is it possible that the Murphys were also trying to kill you as well?
Yes, sir.
And do you know people who have been witnesses to trials involving any of the Jacksonville groups or gangs?
Can you repeat your question?
Do you know witnesses who have been in, you have people who have been witnesses in trials to any of the people in Jacksonville gangs or groups?
Yes, sir.
All right. And to be a witness sometimes can be a dangerous thing.
Objection, Your Honor.
Can it be dangerous to be a witness in a case?
Yes, sir.
If somebody labels you as a snitch or anything like that, that could be dangerous in Jacksonville?
Yes, sir.
All right. And in Jacksonville, in this back and forth, are you aware of anyone who's been harmed for any sort of allegations that they were a snitch?
No, sir.
Are you aware of any individuals who've been harmed for any allegations that they have been a witness for the state or for the police?
Not that I recall, no, sir.
All right. Are there any rap songs that you know of in Jacksonville about people being harmed for being snitches or for being cooperating witnesses?
Not that I'm aware of.
All right. I'm going to show you something. All right. Do you recognize these?
Yes, sir.
All right. They're photographs.
Yes, sir.
All right. Do you recognize the individual in the photograph?
Yes, sir.
Show the jury, or what are these exhibits?
They're not. I have to introduce them to evidence first, Judge. I'm laying foundation and authentication.
Do you know what state the witness is being shown?
Yes, Your Honor.
So, are these fair and accurate depictions of the person that you know
Yes, sir.
here? All right. At this time, I'd seek to move what's been marked as Defense Exhibit 6 into evidence.
Do you have a physical copy?
I have a flash drive.
Well, can't admit a hard drive.
I think these all the time. A flash drive?
What else is on the flash drive?
One of the flash. It's just this.
Well, okay. It can be preliminarily admitted, subject to everyone taking a look at it, and make sure there's nothing else on that flash drive. Have you seen the?
I should see it. I did see the exhibits.
Okay, so anyway, it's admitted, but you guys just need, before it goes back to the jury, just got to make sure you all look at the flash drive and that everything's on there is what should be on there. Nothing that should not be on there. And that'll be defense exhibit. What was it? 6? Okay.
I'm going to publish Exhibit 6 to the jury. This photograph, do you see Charles Jones with the hand sign in this photograph?
Yes, sir.
All right. Again, is Charles Jones throwing up a hand sign that is not a 6-block hand sign?
Yes, sir.
All right. And this hand sign doesn't mean that he's involved in another gang, correct?
No, sir.
The same sort of hand sign in this photograph?
Yes, sir.
All right. And this does not mean that Charles Jones is a part of any other group or gang?
No, sir.
That's it. You're in Jacksonville. You're popular.
Yes, sir.
Maybe even outside of Jacksonville, you're popular.
Yes, sir.
You're popular because of what happened at Rains.
Yes, sir. You can say.
All right. And there are people who talk about you who you don't even know.
Yes, sir.
They talk about what happened at the high school.
Most likely, yes, sir.
And it would not be crazy to think that there are other women out there or men out there who talk about you and what happened at Rains High School.
Yes, sir.
And who did that in 2018, right?
Yes, sir.
And any of the years after that.
Yes, sir.
You said that Charles Jones was making fun of Gutta Zay for Gutta Zay having fake clothes.
Yes, sir.
All right. Like you mean when you say fake clothes, you mean like fake designer clothes?
Yes, sir.
So Gutta Zay portrays to be someone online that he's not.
I wouldn't say that off of wearing fake designer clothes, but I know it was posted about Charles clowning him about fake designer clothes.
Okay. So he wears, from your knowledge, he wears fake designer clothes.
Yes,
But,
yes, sir.
but posted on social media as though it's real designer clothes.
Yes, sir.
And Julio Foolio, he had millions of followers.
Yes, sir.
On social media.
Yes, sir.
The followers that he had, were they also millions of followers on Instagram?
Yes, sir.
Did Young and Ace also have millions of followers?
Yes, sir.
Also on Instagram, he had millions of followers?
Yes, sir.
All right, I have no further questions.
Okay, thank you. May this witness be excused?
Yes.
Okay, thank you, Mr. Howard. You are now excused. All right, very good. Let's take a quick 5-minute comfort break, okay? We'll be right back.
All right. Jury's in, Judge.
Okay, very good. Okay, defense, call your next witness.
Before you have a seat, raise your right hand, please.
You swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, that's right.
Okay, you may proceed.
Thank you. Mr. Alava, how you doing?
How you doing?
All right. Where do you currently live? Don't give me the address. Do you live in Florida?
No, I live in New York.
All right. At any point in time, did you have any property in Florida?
I rented out Airbnbs to properties in Florida.
Okay. The Airbnb that you rented out, do you know the address of that Airbnb?
Yes. One of them was 13801 Heritage Club Drive. And the other one was, I don't remember correctly, the next one.
All right, no problem. That Airbnb, was that in Tampa?
Yes, correct, both.
All right, both the Airbnbs were in Tampa. Were they, well, you have to say yes for the
Yes.
record, I'm sorry. Okay, and were they in the same community?
Yes, same townhouse community.
All right. How long did you own these Airbnbs for?
Well, I rented them out for about a year.
About a year?
Yes.
All right, and what time frame was that? Can you tell me?
I believe it was around April of 23 to July of 2024.
Okay. And so the Airbnb that you had multiple tenants?
Correct. So it was subleasing, and then Airbnb took care of just bringing in tenants on a daily, weekly schedule.
All right. The Airbnb that you had, that you were, renting out, did you have employees?
Yes.
Did those employees run the business, so to speak, of the Airbnb?
Yes. So I had virtual employees in the Philippines, and I also had a cleaning staff local to Tampa.
Okay. The cleaning staff would do what?
They would clean before and after every guest. They will make sure everything in the house is stocked, make sure there's nothing missing, make sure the guests have everything they needed, basically.
All right. The cleaning staff, they weren't perfect.
No, I won't. No.
So sometimes maybe there were things that were not done correctly.
Yeah, I would say so. There were times where there was complaints, and my job as the owner was to get in between that and escalate it and help them out.
All right. This the Airbnbs, did they both have Ring cameras?
Correct, yes.
Let's identify the Airbnb that's pertinent to this case. Is there or were there one of the Airbnbs that was subject to some sort of investigation from the police?
Yes.
All right. Which one was that? Was that the address that you do know or the one that you don't know?
The one I don't know, and if I'm correct, it's on the top of my head. I think it's 3703 Gazebo, I think it was called, something like that. The street name.
Okay. So let's call it the Gazebo Airbnb.
Mhm.
All right. That Gazebo Airbnb has a Ring camera in the front,
Correct, in the front.
covering the front door.
Yes.
All right. The Ring camera system also is accompanied by a lock system.
Yeah, so we had the sludge and code. It's not together per se, but they do mix. They were,
Okay.
yeah.
So they're not, I guess, connected, but they sometimes can work together.
They were connected through my CRM. So my CRM would integrate with both of them separately.
Okay. Now, but they're different companies,
Yes,
different
correct.
products.
Separate companies, yes.
This locking system, did it also have records of when the door locked and unlocked?
Yes, so it was a master lock. So the reason I liked it for the business was because it gave you a history. Anytime anybody opened the door, closed the door, or I could even lock it myself manually as well from New York.
When you say that it gives a history about opening the door, is the history about the door? Does the history record show when the door is open or when it's unlocked or locked?
The records show whenever the lock moves either left or right when it's open or unlocked.
Okay. All right. I want to show you a video, which is State's Exhibit 61A. One. Have you ever seen this video before? Completely.
Yes.
All right. And is this the Gazebo Airbnb?
Correct.
The date on the bottom is June 22nd, 2024.
I see it.
Is that the correct date?
Yes. It should.
And then time on it is 1900 hours 55.
Yes, I see it.
Is that 7:55?
Correct.
All right. And you see a woman there at the front door?
Yes.
Now, this camera system, it operates on what?
It was sensitivity, basically. So whenever somebody will move, it's supposed to record it.
All right. Does it always record when someone moves by the door?
It's supposed to, but it wasn't 100% perfect.
All right. You had issues with that sometimes?
Yeah, definitely.
The issues that you had with the Ring camera not always recording, did those issues intensify at all towards the end of your ownership of the Airbnb?
Intensify, not really. It was something more casual throughout the whole time I owned the Airbnb. It wasn't really a big issue unless it had to do with like too many guests or a party, something like that. That's when we would go in and look at it.
Okay. Now, you see the time on this video, correct?
Correct.
I want to play the video and ask you a question. Do you hear an individual saying "my bad" on the
Yes,
video?
I do.
Is that you?
No, it's not.
All right. Is that someone inside the Airbnb?
It sounds like yes.
All right. The intercom system. Is there an intercom system for the Ring camera?
Yes, there is.
And did you ever used to activate or use the intercom system yourself?
Only when it was needed.
All right. Was it needed on June 22nd, 2024?
No, I don't know.
The intercom system, you did not use it on June 22nd, 2024?
No.
Did you unlock the door remotely on June 22nd of 2024?
No.
The person that was let in, did you see them put in a code?
No, I did not see them.
I want to show you What's in evidence as State's Exhibit 66? What is this document, to your knowledge?
Yeah, so this was the slide and code, the history. So anytime, so as you can see, Tampa 1202, that's one of the Airbnbs, and then it shows the date and by time of the transactions, basically.
I'm sorry. I think the Tampa 1202, is that the gazebo?
Yes, correct.
All right. Do you see the time here, 7:55, unlocked by access code?
Mm-hmm.
Just for the record, is that yes?
Yes.
The court reporter is
Sorry
taking
about
it down. All right. Now, it says unlocked by access code, but at 7:55, you did not see anyone put in the code on the camera. Is that correct?
Correct.
All right. Now, is this locking system, you know of it ever to be incorrect?
No, it was actually more accurate than the ring.
All right. Now, that 7:55 unlocked by access code, is that an example of the ring camera not picking up an individual in front of the camera?
Yes, because in the video, we didn't see anybody there at 7:55. So obviously when they pressed the access code, it had to be in the front door, but if the ring camera didn't share, so it didn't pick it up.
All right. I don't have any other questions. Thank you.
Hey, Cross, just
Mr. Alava, actually, can I use that example? Thank you. Mr. Alava, you had seen the ring video and you had sent that to a Tampa police detective, is that correct?
Correct. I sent it to, I believe, two people, a sergeant, something
Sergeant Rachel Cholnick and Detective, let me look at the email.
like that. Nick McGill, I think, I believe.
Detective McGill, that's correct.
Yes.
And when we're looking at this, I'm going to go down here, unlocked by access code. Right before it, you have access code deleted. Does that happen when you have an Airbnb guest no longer there? Is that access code originally given to them deleted?
Correct. So it's all automated. So the CRM would, anytime a guest will leave, then their code will be deleted. Anytime a guest will come in, they have a new access code automatically placed as well.
And then you had already talked about this one at 7:55 where it is unlocked by access code. That's that new Airbnb guest using their new code. Is that correct?
Yes, that's anybody who comes in using that code.
And obviously you saw that video where the person walks up and knocks and the person has already gone in, correct?
Correct.
So the camera did go on. It was just delayed and did not capture that first person. Is that correct?
Oh, yeah. So from the video, I just see the lady there. I don't see anybody beforehand coming in, but it shows like somebody's already inside.
Okay. And then you saw the second video where the door is already opened and that person, that lady walks right in, correct?
Correct.
So again, that was captured on the Ring camera. And then we show the 7:59 locked and unlocked, and there is no video for that. You said that this locked log is very accurate, correct?
Correct.
And can a person just unlock the door and not open the door? You see what I'm saying? Like if somebody was within the Airbnb, can they unlock it just to test to see if it's locked, which would be reflected on this lock log? Is that correct?
Correct. So anytime someone goes left or right on the lock, it will go there in the transactions.
Yeah, so if the person just went left and right, but never actually opened the door and went out, it would not activate a Ring camera. Is that correct?
Correct. It will activate that, not the Ring camera.
And you have a back sliding glass door in that Airbnb.
Correct.
And there is no Ring camera that covers the back of that door. Is that correct?
No camera, and didn't have a lock per se, just sliding. It wasn't physical or code per se.
In fact, Airbnb policy you have to let your guests know where those cameras are, correct?
It is a policy. I have to make sure I let them know exactly where they are, and I can only have it outside on the front, nowhere in the inside, anything like that.
And so anyone that is not unlocking and locking that front door, there is another access point where they can get in your Airbnb at that lane, at the Gazebo Pond Lane, correct?
Unfortunately, yes.
And that's the back door.
Yes.
And you got to go through the back door, the sliding glass door, and through a back gate, and then through kind of a grassy field to get to the parking lot.
Correct.
And there would be no record of anybody coming in and out of that back sliding glass door.
Correct.
Okay, I have nothing further, Judge.
Okay, redirect.
Just a quick question. The access code that's given to the tenants, that access code gets sent through the Airbnb app?
Correct.
All right, and it gets sent to the person who booked the Airbnb?
Correct. All communication is through the Airbnb portal and the app, and then based off that person's account.
All right, no further questions.
Okay, may this witness be excused?
Yes.
Thank you, sir. You're free,
Thank you.
you're free to go. All right, who's your next witness?
Right, sir. Before you have a seat, raise your right hand, face the clerk.
Yes, her face is not to be broadcast.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Yes.
Oh my gosh, this is like amazing. Oh my goodness, a bird is quick. I don't know what that means. I don't know what that means. A bird this fast?
Gonzalez, are we waiting for Mr. Hernandez or no?
Judge, he was not with us downstairs, so I'm not sure where he is.
Okay.
I'm sure he's close. If you don't
Okay.
mind, can I text him?
Give me a second. I'm gonna add it back to it. It's probably because it's switching the thing, but they haven't started. So we still good.
The one that is in the middle there, he's gonna walk back with you. Which one? He's in the middle there, Lugo. You know Lugo?
Oh, okay, yeah. Why?
Okay.
He's not, okay, yours, David. Yes.
I don't know what this means in regards to this. If they found them guilty, not guilty, it looks like we're getting the courtroom together with all the people in there. Wow, oh wow.
Judge, Mr. Hernandez says that he would be about 10 minutes.
Okay. See.
He's at Starbucks, Judge, which is, I guess, on the corner.
Yeah.
4 blocks away. Okay.
All right. Okay.
You know, the strange part about all this is that they never even put up a verdict clock. I had up Court TV because, you know, we watching the Josie Dykeman case. And
Judge, the court can go on.
Yeah, okay, let's do that, just because everyone else is
Understood,
here.
Your Honor.
they had a verdict watch clock on, but on this one, they don't have a verdict watch on. So that is weird. But here we go.
All right, very good. It's my understanding the jury has reached a verdict, correct?
Yes, ma'am.
Okay. Bring in.
Thank you, Judge.
I just need to remind everyone again, there's not to be any audible reaction after the jury's verdict is read, okay?
Ready, Judge?
Yeah.
All rise. All judges are in, Judge.
Okay, very good. Everyone have a seat. And it's my understanding the jury has reached its verdict for the penalty phase, correct? All right, very good. You would hand the verdict form to the judge.
Yes, ma'am.
Defendant Isaiah Chance, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. We, the jury, finds Isaiah Chance should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, in Hillsborough County, Florida, Miss C.S., foreperson of the jury. Defendant Sean Gathright, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, in Hillsborough County, Florida, C.S., foreperson of the jury. Defendant Rashad Murphy, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more of the aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, in Hillsborough County, Florida, C.S., foreperson of the jury. Defendant Davion Murphy, verdict form, jury verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole. Stated this 15th day of May, 2026, CS for a person of the jury.
All right, members of the jury, now I'm going to ask you all the same questions similar to what happened after the guilt phase for the whole jury. So I'm going to ask you about the jury's decisions that you have just heard. Juror number 9, initials DN. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 16, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 19, initials LY. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 24, initials WW. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 32, initials CRP. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 47, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 49, initials CG. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 78, initials AC. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 142, initials TL. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And juror 157, initials CS. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And juror 158, initials JH. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And juror 167, initials JE. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? All right, I have one last formal instruction for you all, then I have something more personal to say. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affairs as long as they wish them. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a much more personal note, these are tough cases. These are tough cases. And I've handled a lot of tough cases. This is my first rodeo as far as handling tough cases. This one takes the cake. This one was one of the up to date in my 24 years of doing this as a judge. One of the toughest cases. And you all are amazing. You're amazing people. You are smart, you are attentive, you are patient, and you are just. You're just. And I just want, on behalf of everyone involved, not just the parties, the attorneys, myself, our entire community,
owes you a debt of gratitude. And I wish I could do something more for you other than just say how amazing you are. I did have the bailiff give you all just a small medallion, it's just a token. I wish there was more that I could do, but that is all I can do. You all should go home, and as you resume your lives, be so proud of yourselves for the citizens you are and the sacrifice that you made for all of us in our legal system. We are eternally grateful. With that, your jury service is now complete. Thank you.
All right. Jury's up.
Okay, very good. Okay, so we need to set a date for sentencing and all post-trial motions, all right? So, how much time do you all need to get the motions drafted? We look at sometime in June?
Yes, Judge, I would ask for a couple of weeks.
Okay. So, I know summer can be a little tricky. How are you guys looking the week of June 22nd? I could do the 22nd anytime, the 23rd in the morning.
Judge, the 22nd would work in the afternoon.
Okay. Mr. Gonzalez?
Fine with 22nd, the afternoon, Judge.
Okay. Ms. Finkelstein? That works. Okay, Mr. Sonardi Mastuki?
Afternoon is fine.
Okay, Mr. Petridis?
I have a trial that week, was just a 1 day here in Hillsborough, so I can just get it someday that week.
Sure, and just let me know who the judge is, I'll make a call, not to worry.
Okay.
Okay, so we're gonna set sentencing for June 22nd at 1:30. And all pre-trial post-trial motions need to be filed, no later than, June 15th. Actually, make that June 12th close of business, and state if you're gonna follow the apply executive thing. Okay? All right, very good. And sentencing, if anybody would like to speak, they can. That would be from the victim's family or friends, same with defendants. I mean, the sentence is mandatory, but cases like this, when it comes to sentencing, I would like to give everyone a chance to say whatever they feel needs to be said, as long as it's respectful. Okay? Okay, very good. See you all then. We are concluded.
So I'm gonna replay the verdict just one more time for people that may have came in late or whatever the case may be. What I would like to say is that okay, I figured out because I was like, why do we have to have a sentencing date? And I think that's for impact statements. I think that's for the family to come and say how this has impacted them. It's to give them a formal opportunity to let it all out on the line, even though we know I mean, they've been sentenced to LWOP, and Judge Cisco is not, I do repeat, is not about to go against the grain. Okay? June 22nd. Tanya, get that in the books for us so we can remember. Because you know, I forget. We be in so many cases. We're gonna have to make sure we're gonna have a tally on all these people that gotta be sentenced. Just so everybody knows, whoever is watching Josie, they are still deliberating. They are approaching close to 6 hours. I'm gonna replay the verdict in here, and then we will it's crazy when LWOP is the best thing you got coming. All that sweat, oh, they waiting. They got their hands greased. They are licking their fingers over there, the prison guards. They can't wait to get these 4 young huskies. Oh, they can't wait to get them over there, baby. They about to get it all in. About to work them to the bone. Oh, and they young. We can get us a good 40 to 50 out of them. Wow. Who signs up for that? They need to play that guard statement in all schools, as far as I'm concerned. They gonna get it all that sweat, baby. Let me replay it so we can have a clean version. But yeah, they about to get all this sweat for those that didn't see it. Get all that labor, baby. I guess when you on DP, maybe you don't give them that sweat. But baby, they gonna get that sweat. I should have knew, like when they came back so fast, I should have knew it was gonna be LWAP. Because I think if you performing it would figuring out if they was gonna die would take a lot longer.
Right?
Yes, ma'am.
Okay. Bring in.
Thank you, Judge. Okay.
And I just need to remind everyone again, there's not to be any audible reaction after the jury's verdict is read, okay?
Ready, Judge?
Yeah.
All rise. All judges are in, Judge.
Okay, very good. Everyone have a seat. And it's my understanding the jury has reached its verdict for the penalty phase, correct? All right, very good. You would hand the verdict on to the jury.
Yes, ma'am.
Madam Clerk, please publish the verdicts.
Same. Defendant Isaiah Chance, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Isaiah Chance was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Isaiah Chance should be sentenced to life in prison without the possibility of parole or death. We, the jury, finds Isaiah Chance should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026 in Hillsborough County, Florida, Miss C.S., foreperson of the jury. Defendant Sean Gathright, Verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Sean Gathright was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Sean Gathright should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Sean Gathright should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026 in Hillsborough County, Florida, CS for a person of the jury. Defendant Rashad Murphy, verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Rashad Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more of the aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Rashad Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Rashad Murphy should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026 in Hillsborough County, Florida, CS for a person of the jury. Defendant Davion Murphy, verdict form, jury verdict form, penalty phase. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy committed the homicide in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy created a great risk of death to many persons. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was contemporaneously convicted of a felony involving the use of violence to another person. Yes. We, the jury, unanimously find the state proved beyond a reasonable doubt that Davion Murphy was a criminal gang member at the time of the homicide. Yes. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more of the mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Davion Murphy should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Davion Murphy should be sentenced to life in prison without the possibility of parole. Dated this 15th day of May, 2026, CS for a person of the jury.
All right, members of the jury, now I'm going to ask you all the same questions similar to what happened after the guilt phase for the whole jury. So I'm going to ask you about the jury's decisions that you have just heard. Juror number 9, initials DN. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 16, initials AN. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 19, initials LY. Do
Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 24, initials WW. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 32, initials CRP. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 47, initials AM. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 49, initials CG. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 78, initials AC. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror number 142, initials TL. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And juror 157, initials CS. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And juror 158, initials JH. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? And juror 167, initials JE. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? All right, I have one last formal instruction for you all, then I have something more personal to say. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affairs as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a much more personal note, these are tough cases. These are tough cases. And I've handled a lot of tough cases. This is my first rodeo as far as handling tough cases. This one takes the cake. This one was one of the up to date in my 24 years of doing this as a judge.
So hopefully everybody got a chance to see the verdict. Oh man, okay. Well, 4 of them bite the dust. We have sentencing that's going to be scheduled for June the 22nd. Everybody got LWOP. So y'all know what that means up there in Florida. I mean, I can't see it no better than what he said it. All that good old sweat equity. Oh man, oh man, oh man. That's gonna be the word for days to come. What can I say? Hopefully you enjoyed your time here. I'm glad that everybody was able to come back and watch it. If you're on a replay team, don't forget to drop a note in regards to watching the verdict. I truly appreciate it. We are over still in the Josie trial. We are waiting on verdict watch over there for her accused of unaliving her stepson. So currently I have a verdict watch. They are actually 6 hours in to their verdict. They watched some video. Yeah, and they 6 hours in. So, here at Take It to Trial, we all over here. What type of work would they do? Jail work. Jail work. That's what they'll do. Jail work. I don't know. Make license plates. I don't know what they doing. Cooking, cleaning, dirty laundry, floors. Who knows? Who knows? Well, all they know is it's free labor. And they signed up for it. Signed, sealed, delivered. The state of Florida's they yours. They're gonna get a number coming in and they're gonna have the same number when they leaving out. Oh my goodness. Hey, Maurice. All right, guys. So once this stream in, it will redirect you over to the Josie trial. So if you are following that trial, we are replaying testimony. We do have a verdict watch over there. Most likely later today, I think. No, probably tomorrow morning, we will get into our Alex Murdoch. Talk about him and Paw. Thank you to all the new members, all the new subscribers, all the mods, the chat. I truly, truly, truly appreciate you. Thank you so much for hanging out with us over here at Take It to Trial. I'm your girl, Sweet Pea, and I will catch you out here on these YouTube streets if I don't catch you in the chat. All right, peace.